Court is calling 2025 CR 003791 State versus Andre Xavier Crawford. Could I have parties announced for the record, please?
Ethan will be for Mr. Crawford.
And are you Mr. Crawford?
Yes, ma'am.
Counsel, have you received all discovery? Did you review it with your client?
I have.
Court will find that the state is in compliance with discovery. Mr. Crawford, did you review the document entitled Application for Deferred Adjudication with your attorney?
Yes, ma'am.
Did you understand it and sign it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney?
Yes, ma'am.
Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
I do, Judge.
State, are you proceeding on the indictment as presented?
Yes, sir.
Mr. Crawford, did you review court admonishments with your attorney? Did you understand it?
Yes, ma'am.
Did you sign it in all the appropriate places? You're charged with theft of property, $2,500 to $30,000 as a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 2 years in the state jail facility and up to $10,000 fine?
Yes, sir.
Counsel, has your client been able to provide you with any defenses?
He has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I believe he does.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do.
Mr. Crawford, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes, sir.
Did you understand by entering this plea, if you are not a U.S. citizen, you could be deported, denied naturalization, and not allowed re-entry into the country? Did you understand?
Yes, sir.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, sir.
According to the plea, there's a $0 fine. State recommends deferred adjudication. There's to be restitution in the amount of $3,746.99 to target. Did you understand that to be the plea?
Yes, sir.
Defense?
Yes.
State?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, sir.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, sir.
Counsel, have there been any such motions?
No.
Outside the agreement, the state is recommending that your deferred adjudication be for a term of 5 years. There'll be a TAP evaluation, 200 hours of community service restitution, no contact with target, and Michaela, Makhayla, Pean, Pean, a mental health evaluation, follow recommendations, the anti-theft course, and healthy relationships course. Did you understand those were recommendations by the state and the court does not have to follow those recommendations? Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
I'm guilty. I believe the paperwork says no contest.
All right. Do you understand what a no contest plea is? You're not saying that you're guilty in layman's terms. You're not saying you're guilty. You're not saying you're not guilty. You're just not fighting the charges against you. However, I can still find there's sufficient evidence to find you guilty. But because you've applied for deferred adjudication, if I follow your agreement, I'm not going to find you guilty. I'm going to defer finding of guilt. Do you understand?
Yes, sir.
Normally, people will enter no contest pleas if there is any type of restitution is owed, because people can always sue you civilly. So sometimes your attorney is trying to protect you civilly. So by pleading no contest, if there is a civil suit involved, whoever wants to sue you out of something that arose from this incident, they would have to go to a civil court and prove that. Do you understand?
Yes, sir.
So are you pleading guilty or no contest?
No contest.
All right, state any evidence to support the defendant's plea?
State offer states one in attachment.
No objection, Judge.
All right, did you review the waiver and consent to stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, so here's my question. I see that they say that he stole Apple iPad Air, which I understand. But in one place, on June 24th, 2024, they say he stole an Apple iPad and it costs, I'm sorry, an Apple iPad Air, and it costs $799. Then they said he stole another Apple iPad Air and it costs $1,200.
This is our based on like the storage space that the iPads have, and so like if it's like a 60 gigabyte, then that would be cheaper than a 120 gigabyte storage, so.
So
It's
the,
attached, I think, like, nice to you, but.
sure. So the Apple iPads have different,
They have
Storage.
different storage.
oh, okay.
Yeah, so I did attach this, and so like
Okay.
here, you'll see the
Oh.
storage on it.
Thank you. That explains it.
Guess otherwise you'd want to go shopping.
I'm sorry.
I guess otherwise you'd want to go shopping for the cheaper iPad with the same storage.
Oh, I have no idea. I don't do Apple. No offense to Apple. I
Yeah.
just, my thing is, I'm not trying to learn anything new, computer related. I still on my phone, which is, I think, a 6, and they're already on 29. All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty. The court will defer finding you guilt as you've applied for deferred adjudication. So these are some questions I have. Number 1, why is there a request for mental health evaluation?
So the recommendations that are below the line are based on my analysis of a different case. So it's a global offer where he's not going to be on supervision for the misdemeanor case, but that's where the conditions.
All right, so that's the mental health evaluation is based upon the misdemeanor case?
Yeah, the mental health evaluation, the healthy relationships, and then the no contact order with the named individual.
All right, and who is the named individual? What's the relationship to the defendant? Okay. All right, so then my next question for you, Mr. Crawford, when are you going to have this $3,746.99?
I don't know exactly, but less than a year for sure, or less than like
When are you going to be able to make a down payment towards this?
as soon as possible.
What does that mean, though?
I get paid on next Tuesday.
All right, what do you do?
I work at BJ's restaurant.
All right, so how much you're going to be able to pay towards this?
I can put down 300.
300?
Yes, ma'am.
All right, when will you be able to put down 500?
500. I don't know the exact date, but I have a phone on me.
Oh, do you want to look at a phone now?
I have my phone on me.
Okay, oh yeah, you can look at it.
The 16th of October.
October 16th?
Yes, ma'am.
All right, so this is what we're gonna do. I'm going to sentence you. Norma?
Yes.
Are you able to recall this back on October 21st?
Yes.
All right, so you're gonna be sentenced on October 21st. Ms. Abrams? He's gonna have $500. Should he make that out to someone other than, all right. So he's gonna bring in $500 towards Target, and then when you come back on October 21st, you need to be able to tell me how much you'll be able to pay per month towards this restitution. All right. So we're going to recall you back on October 12th.
Did you put October 12th or?
I'm sorry, October 25th, 21st. Yeah. The days are just all over my head today. So we're bringing you back on October 21st. On October 21st, you're going to need to bring $500. Do it in the form of cashier's check or money order. What do you need? All right, so either a cashier's check or a money order.
Yes, sir.
And usually the money orders and cashier's check, they usually cost the same. So you can get the cashier's check or money order from a bank, or either you can get the money order from, HEB or some of those other stores. All right, so we will see you back then. Once you get the reset form, and you sign it, you're excused, okay?
Yes, sir.
All right, thank you.
Judge, will you need me on that? Will you need me on that?
Oh, yes.
Okay.
Thursday.
Roy Sanchez Jr. Good morning.
Prior to today, we had an offer with a plea to another case in another court with a different defense attorney. This case would be resolved.
Mhm.
He's accepted the offer. However, while he signed plea paperwork on September 11th, there was a issue that court recalled him to the 18th. This case will be dismissed once he pleads on that other case.
So he's been recalled down there for the
I
18th?
believe so, but what they do is afternoon docket at 1:30 to like 3:30. So I'm asking if we could recall this to Monday the following week.
All right, everyone, please whisper. So that will be done on the 18th, correct?
Yes,
Norma,
Yeah, okay.
recall this on September 22nd, and then if that is done, then we won't have him
yes,
here.
Judge.
All right, so we'll see you back on September 22nd.
Thank you, Judge.
Thank you.
Follow the bailiff. Yes.
All right, the court is calling 2024 CR 009393, State versus Paul Anthony Ramirez. Can I have parties announced for the record?
Attorney Bill Simmons for defense.
And are you Paul Anthony Ramirez?
Yes, ma'am.
Okay, on this case, could I have the original motion to revoke?
Yeah.
I only have the first amended. Okay, thank you.
Yes, ma'am, sorry.
Mr. Ramirez, did you review the motion to revoke community supervision and first amended motion to revoke community supervision with your attorney?
Yes, ma'am.
Did you understand it?
Yes, ma'am.
Are you the same Paul Anthony Ramirez who was placed on community supervision in 2024 CR 009393 for the offense of possession of a controlled substance penalty group 1, 4,200 grams on October 31st, 2024 for a term of 6 years? Is that you?
Yes, ma'am.
All right, state.
Violation of condition number 4 in Bear County, Texas, the defendant Paul Anthony Ramirez did then and there fail to report to the supervision officer as directed for the months of April, May, and June 2025 in violation of condition number 4.
How do you plead to that? True or not true?
True.
State.
No
Any
objection.
objections?
No objection, Your Honor.
Did you understand by pleading true to violation of condition number 4, the court could find it true, grant the motion, and sentence you up to 4 years in the prison?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 4?
Yes, ma'am.
Court will find violation of condition number 4 true. Is there a proposed agreement?
Yes, Your Honor. Is to grant the state's motion, revoke the defendant's community supervision, reform his judgment to a sentence of 3 years in prison. And the state is going to take into consideration cause number 2025 PF 31486 and 2025 PF 31487.
All right, and what are those allegations in those?
It's an unauthorized use, Judge, and a possession condition.
All right. So what has he done on probation? Other than pick up new cases?
Your Honor, the times that he had missed, and it's, we have waived, those of allegations obviously have been, waived, but if the court looks at the, MTR, he was in Medina County for another offense,
All right,
fundamental.
so was he ever released while he was on probation?
You did report some of it.
Yes,
correct?
Do you want to raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand, state your name for the record.
Anthony Ramirez.
All right, so what have you done other than it's alleged that you picked up 2 new cases?
I reported like 3 or 4 times. I paid those times that I did go report.
All right, so you've reported 3 or 4 times since October 2024.
Whenever I was released from here, I reported like 3 times, three times.
So why are you only reporting 3 times?
Because after that, I was in Medina County.
And in custody in Medina County for what?
Unauthorized use.
All right, and is that an unauthorized use that's alleged to have been committed after he was placed on probation?
My understanding is yes, Your Honor, but out of an abundance of caution, would just simply ask the court, or we have the summary here, I'd like to, just take a look at the dates just to make sure, but I am pretty sure it was after.
Yes, sir.
It was after the new charge after you got released.
Yes, sir.
So then here's my question for you. Why should I give you less than what you bargained for when the only thing you've done is report 3 times and you picked up a new case, you ended up in Medina County, and then you have 2 new charges here that the state is taking in consideration? And I'm assuming those 2 new charges, was that after he was placed on probation?
Yes, Your Honor, they were August.
So why?
Well, these cases didn't have nothing to do with me as far as the unauthorized use.
Okay.
How it all happened is, if you look into it, but
And what were Your Honor, on the unauthorized use here, basically, he was with but I would think that the evidence would suggest, I don't want to put words in about, the evidence would suggest that the actual taking of the vehicle was by another young lady in Corpus Christi that he had an engagement with here in Bear County that may or may not have involved provable possession of illicit substances, Judge. But it's not, but in no way are we trying to represent to the court that it's acceptable behavior as while he's on probation. We would ask the court to, though, give some consideration, even though we've been here before. This is a young man who's basically been raised in prison. He went to prison for the first time at, I believe, 14. He had some issues with his decision-making, Judge, but with the underlying sentence of 4, we think, well, that's a plea bargain process, and so we think the 3 would be fair, but we would yield to the court on that. The other thing that could be done at this time, if he didn't have the cases pending in Medina County, I will say the first thing that came out of his mouth is that he needs help with his, would you agree? Help with I'll let you complete my sentence.
with that, Judge,
Well,
I really do need. Yes,
Okay, good.
I really need help with the substance abuse. That's the whole point of it. I'd rather have take the 3 years of TDC just to, overall, I think it'll help me out than to just go out and do the program, whatever it is.
But I mean, you were given a chance when I placed you on probation to get it together, right?
The problem is the drug problem. I was still.
Oh, no, you could have came here and I would have said, okay, let's take care of your drug issue. Let's give you whatever help you need with drug issues. But you didn't reach out to your probation officer. You didn't reach out to the court. You reached out to take a ride with somebody in a stolen vehicle. And the last time I saw you, did you have the teardrops or is that something new?
No, same thing.
All right. And then the crown
All the same.
and then the Playboy bunny
Everything.
And then the dollar sign?
It's all old,
How old are you?
28.
All right, you're 28 years old. And you went to prison when you were 14? You know, TYC, that's what we would call it.
TDC.
Is somebody sending somebody to TDC at 14?
I think,
My dear
Your
County
Honor,
Hero.
given.
No, I mean, you start out in TYC. They're not sending 14 years old to prison.
uh,
Then once you become of age, then they will send you to prison. So I can see you.
I was sentenced at 14, then 15, I was in TDC, the Clemens Unit, YP. From all the way till I was 21.
Well, is somebody gonna sue Texas for sending a 15-year-old to prison?
Your Honor, I
Well, I
will,
mean, I'm always interested in learning new law. There are a lot of defense attorneys in here. Do they send people in Texas to adult prison when they're 15?
Your Honor, I think that just at sometimes, okay, and again, not to contradict what he's saying, but I think sometimes it just kind of blurs and runs in together when you've been in since you're 14.
Well, let me just tell you this.
I can tell you this, there's so
Any legal advice, but if you were sent to prison at 15, somebody needs to file a suit, although the statute of limitations may have ran since you're 28. But this is what I can tell you.
And for the record, Your Honor, obviously, I did not represent him.
No, I appreciate that.
For the people in,
This is what I can tell you. At some point, your actions are your own. You can't keep blaming your actions on the fact that you went to TYC at 14. You got to change your life. All right. I'm going to follow the agreement that you worked out based upon what your attorney is saying and what the state is saying with regards to the unauthorized use. I guess that's what we do since the time of Adam and Eve. We still blame the woman for our own actions. So, are you waiving your right to appeal?
Yes, ma'am.
All right, the court is going to sentence you to 3 years in the prison, give you credit for any time served. I'm going to request the therapeutic community. There's to be no unsupervised contact with minors, no residing with minors. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it?
Yes, ma'am.
Right, because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes.
All right, we can go off the record. When you're released from custody, if you can't find somebody to help you get on the straight and narrow, if I'm still here, you can come back here. I'll find an inpatient treatment facility for you. Now, let me just explain to you, the reason why I'm saying no unsupervised contact with minors and no residing with minors is because you really shouldn't be around minors because you'd be a bad influence. And until you get your life together, that's the way it should be. And a lot of women will see you when you come out of prison and they're going to see somebody who's a good catch.
Yes, ma'am.
And we can't have that until you get your life together, okay? All right, good luck to you, all right? Oh, and I'm so sorry. Can we go back on the record? Court is going to take in consideration 2025 PF 31487 and 2025 PF 31486. And if you could hold him for a moment so he can get a copy of this, please. Yeah, thank you. And I don't know if you all have a case number for Medina County.
I know.
I believe they were listed on the, NPR judge. So,
Well, if you all have that and you bring that number back to me, I'll make sure that this runs concurrently with that.
okay, I'll get that for you, Judge.
All right, thank you. Alicia Rubio,
Person ready, Your Honor.
court is calling 2022 CR 3602. State versus Alicia Rubio. Could I have parties announce?
Rick Payne for the state of Texas.
Sharon Thorne for the defendant.
And are you Alicia Rubio?
Yes, ma'am.
Did you review the document entitled Motion to Revoke Community Supervision with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Alicia Rubio who was placed on community supervision in 2022 CR 3602 for the offense of assault family household member with a previous conviction on June 30th, 2022 for a term of 4 years? Is that you?
Yes, ma'am.
State?
Yes, Your Honor, violation of condition number 39. On or about the third day of January 2025 in Bear County, Texas, the defendant, Alicia Rubio, who then and there failed to attend felony drug court evaluation in violation of condition number 39.
How do you plead to that? True or not true?
True.
State will waive the remaining violations.
Any objections to the state's waivers?
No, Your Honor.
Did you understand by pleading true to violation of condition 39, the court could find it true, grant the motion, and sentence you to 4 years in the prison?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 39?
Yes, ma'am.
Court will find violation of condition 39 true. Is there a proposed agreement?
There is, Your Honor, that is to deny the motion, alter and amend the defendant's probation conditions to add DDRF followed by DDRF aftercare.
That is our understanding, Your Honor.
Why should I do that?
Your Honor, my client definitely needs help. She's had a lot of mental health issues and depression. Her father died. And she just basically didn't even get out of the house and did not follow any of your terms of probation, but she does want help. And she needs the help. And the state and probation wants to help her. So we are asking you to do that.
All right, so this is not the first motion to revoke she's had with me. Has she done anything on probation?
She's done some community service hours.
In all my communities.
Other than that, I don't think we'll see a lot.
All right, probation, what has she done?
Judge, I would have to look into the community service hours part of that. But the only thing that I have that she has completed was basically her TAP evaluation. She did her DNA testing and there's a $90 credit on the account.
I mean, she hasn't done anything and we've been here before. And the court recommended felony drug court for her because we had issues with drug use. And nobody can help anybody who doesn't want to be helped. She was here December 2024 for a violation of condition number 4, not reporting, disappearing. I denied the motion, alternate amended conditions to include a TAP evaluation out of custody, a mental health evaluation out of custody, and a referral to felony drug court out of custody. And then she disappeared and she's been missing since January. So it's obvious to the court, there's nothing I can do here. So I'm going to grant the motion and revoke. Do y'all want to recommend amount of time?
Stay with you 4 years.
Defense.
Your Honor, my client, she has 209 days credit, but my client is asking for you to consider reducing that amount to 2 or 3 years, Your Honor. Not to make excuses, but the gentleman that you had before picked up new cases and he
All
gets
right,
3
so
years.
here's the thing. Let me explain something. And defense attorneys will tell you this all the time. And I used to have clients, they said, well, this person got that. Why can't I get this? Or this person got that. Why can't I get that? I treat everybody as an individual because guess what? If I didn't treat everybody as an individual, everybody comes before me. And usually, you know what they tell me? Somebody died in my family. I just got a job yesterday. And if I didn't treat people as an individual, you know what I'd be doing? All those stories that people tell me, sometimes they're true, sometimes they're not true, I would hold it against you.
Right.
So what somebody else receives may not be for you.
Right.
So I'm just looking you at an individual And you're looking at 4 years because that's your range. And what I can tell you is the person who just came before me, because your attorney brought it up, they didn't have a previous motion to revoke.
Right.
So this is your second motion to revoke. And you're coming before me, and I tried to help you with the MIC evaluation, which is what everybody's saying you need. I already tried that. You didn't want it because you didn't do it. I tried helping you with your drug issue. That's why I had felony drug court. You didn't want it. You didn't show up.
Right.
I tried helping you by giving you a TAP evaluation if you were not accepted in felony drug court. You didn't want it because you didn't show up. So the state is asking for 4 years. Yes, the state is asking for 4 years. Your attorney is asking for 2 to 3 years. What I can tell you is I'm not giving you the minimum because you didn't do anything. And this is your second motion to revoke. So you want to raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
My name is Alicia Rubio.
All right, what would you like to say or defense? Would you like to speak to her before she speaks to me, or?
I believe she wants to state why you should give her, the 3 years, Your Honor. And, I'm going to allow her to speak her mind.
With all due respect, Your Honor. I'm requesting your leniency, yes. But I did do my Zoom, my TAP evaluation through Zoom. I did that. I can't pinpoint the exact date, but more or less, it was before the first MTR. I did that through Zoom.
Mhm.
Y'all couldn't find it the first time I came through here, which is why you recommended the second one. Okay, I went through 4 probation officers, 4 different probation officers while I was out there. My last one was Mrs. Spence. I did my parenting class that y'all requested. I did my community service. I reported my change of address.
Did you turn in your parenting classes to them?
Yes, I did.
Probation, can you look to see if you have documentation of parenting classes? Go, continue.
I had, my sponsor, I gave her my sponsor's information. I gave her,
Everyone, please whisper. You may continue. Sorry about that.
thank you. I gave her the information to the program that I was working in San Antonio at Zapata. I gave her all that information. I was doing my meetings at 2 o'clock and at 6 o'clock every day. She had no record of that when my paperwork got to her. And I hold myself accountable for every, missing and not and failing to report. That was my irresponsibility. I agree to that, yes. My depression was something I couldn't control. I wasn't on my medication. I didn't have the strength to leave my house. You know what I mean? I'm not saying that's anybody else's fault but my own. You know what I mean? I'm trying to learn to hold myself accountable, so I'm doing that. I do have a drug problem, but I have been clean. My drug of choice is heroin. I have been clean off of that since I picked up this charge, because my priority is to get back to my mother, especially since I lost my father in March. I want to be with her. I want to grieve with her. I want to do all of that. That's why I'm requesting your leniency.
All right, so here's the thing. I don't know if you've been clean or not because nobody's tested you. You're just telling me this.
The last drug test you requested from me, I was here in your court. It was the same thing. You didn't believe me, and I said I was, and you sent me to drug court to drug test, and my drug test came back clean. You know what I mean? I hold proudly that I'm from where I'm from, and I've been clean. That's something I work very hard to do every day. Because as an addict, that's difficult, especially when I'm grieving the father, my father's loss, or losing my father. I apologize.
You've
That
been
was nothing
missing.
to do.
Here's the thing. You've been missing since January. So I don't know what you've been doing. That's the problem.
And I take that, that was my responsibility. Again, I'm just asking for your leniency. I wanna get back to my mom.
All right, probation, do you have proof of the parenting classes? All right, this is what the court is going to do. The court is finding violation of 39 true. Court is going to grant the motion. The court is going to sentence you to 3 years in the prison. There's a $1,500 fine, time and money to run concurrent. There's an affirmative finding of family violence. There's to be no contact with Ophelia, Ofelia, Ribiel. Give you credit for any time served, and the court will request the therapeutic community. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney, counsel?
Yes, Your Honor.
You do have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you are on community supervision. Because this is a felony conviction and a finding of affirmative violence, you're not allowed to own or possess any weapons or ammunition. If you have a question of what a weapon or ammunition is, you'll need to speak to an attorney. We can go off the record. With regards to the therapeutic community, it doesn't increase the time that you're in custody, but that can help you with any drug issues or mental health issues you may have. Once you're released from custody, if you cannot find a sober living home or somewhere else, just let the court know. If I'm still here, I'll pick up the phone, call somebody to help you, all right? All right, good luck to you, okay?
I have a question, so I'm gonna able to see them.
She's a no
She's my
contact.
victim,
She's a no contact.
Oh, no, you have a no contact order with her.
even after I get out.
Yes. Robert James Quinones. Quinones.
Was so close.
I tried. Sort of like how Notre Dame was so close. I shouldn't say that, should I?
I'm a big believer in taunting this year. Yeah. Last year, not so much.
Yeah.
Somebody said, this year's Texas is last year's Oklahoma.
Oh.
$6 million for Archie, a lot of money.
So has the state tendered an offer?
So Judge, what's happening is there is an unindicted case that the state is going to try to get the file for. If we can do a week, I think we're working at a deal on the new case. This current case, the ag assault and the other ones, I think are going to end up getting dismissed through lack of contact with the complainant. But there's an unindicted felon possession we just found out about.
All right, Ms. Ferguson, I need a 1 week reset. All right, September 23rd.
All
All
right.
right, we'll see you back then.
All right, thank you, Judge.
You're welcome. Yes.
I don't need anything.
All right, Roland Ramirez. Where's your client?
He's in custody, Mr. Ramirez.
Ramirez?
Hello, hi. So how are you doing?
Okay.
So is everything medically okay? All right. So where are we?
Judge, we've been negotiating with the state. We had a plea offer the last time we were here. In the interim, he picked up a new charge. We're awaiting some discovery on that, to try and figure out how we can possibly resolve all of it
All right, who are you conferring with?
with Megan,
Okay.
Mrs. Galloway.
Right. So when do you anticipate on having the other discovery?
George, I would ask for information, because I'm reaching out to the agency right now. Did you have the initial report? However, the videos have been transferred over, because it's been about 3 weeks since the office. Yes.
And those videos, I believe, are either going to help or hurt our case, but it's crucial for us to review.
All right, thank you. All right, Ms. Ferguson, I need a 3-week reset on Roland Ramirez. And it's for discovery. And do you have pending parole? I don't even know why they, Odyssey.
Does it say that? He doesn't have any.
Oh, yeah, they put on here parole.
Yeah, he had questioned me. He thought he was being held on a motion to revoke. But I was like, you're not on probation.
October 7th.
Okay.
All right, we'll have you back here on October 7th.
Thank you, Judge.
Thank you. Jose Alanis Becerra. Where's your client? All right. Morning. So today is plea deadline date.
It is, Judge, spoke with the state. We actually have a new offer and they're approving them for pretrial diversion.
Okay,
So we'd like to apply for that, see if we can get in the program.
all right, so you'll need to apply for that today.
Yes, ma'am.
Ms. Ferguson, I need a PTT date. All right, October 16th. Thank you for dressing appropriately for court.
Thank you, Judge.
All right, thank you. Once he signs the reset form.
Yes, ma'am.
All right, thank you. Mary Elizabeth Sanchez. Good morning. All right, where are we on discovery?
Judge, this is
Good
our
morning.
first occurrence in this case. The assignment was in Mary Sanchez. The indictment is Mary. Close. Cable Green. Apparently the discovery was in a different area and I didn't get discovery. The DA tells me they could straighten that out. I should get discovery shortly. And she also has a PF case that I apparently in a different name.
All right, and
I don't have anything at this point of first discovery. I can't try to figure out where we are.
all right, Dave, were you able to tender an offer?
Your original email one.
All right, you all need to tender an offer off docket. Ms. Ferguson,
Yes,
can you set this for a plea deadline date in 45 days, please? And if your counsel wants you back sooner, he'll let us know. What date?
it would be Thursday, the 30th, October 30th.
All right, we'll have you back on October 30th, and that will be your plea deadline date. All right, do you have any questions about anything? All right, thank you.
Maybe excused.
Yes.
Thank you, Judge.
Ramita's rolling?
Matthew and Siriaga?
Judge, I had been trying to e-file that motion yesterday, but e-file had been down.
Okay,
And so I brought the original into the court. There was a recall from last week when Judge Angelini was here to make sure all our discovery was complete.
Mhm.
That was the only thing that was missing was a CPS motion. I gave the state their copy this morning also.
okay, just 1 second. All right, State, do you have the CPS records?
We do not, and I'm showing that there were unfortunately other requested, so I put out that request rushing today. I'm hoping we could get things very quickly as soon as.
And that's the only outstanding discovery?
I believe so, Judge. Everything on e-discovery I have been able to download.
All right, and how long do you all expect this jury trial to last?
I'm still going through the discovery, Judge, so I'm not certain.
Okay.
The date may be misleading. Mr. Insuriagi was just arrested on this charge about a month ago,
Okay,
so he was just indicted recently.
all right, Ms. Ferguson, on this case, set this for a final discovery in 45 days and state on that date you need to be prepared to tender an offer.
October 30th.
October 30th, is that good for you, counsel?
It should be, Judge. If not, I can let the court know. It should be.
All right, so what's going to end up happening is we're going to bring you back on October 30th. On that date, the state will have tendered an offer to you on that date as well. Then after that, I'm going to give you another reset, give you a chance to discuss the offer with your attorney. And then when you come back, if you all have not reached an agreement, your next date is going to be a jury trial date. Do you understand? Thank you for dressing appropriately for court. Once you sign the reset form, you're excused. Thank you.
Thanks, Judge.
You're welcome. Johnny Joe Gary. Where are we on this case?
This is a separate trial, Judge.
Mhm.
I believe the state's not ready and they're gonna ask me for continuance.
All right, well, I don't have a motion for continuance. So just have a seat and we'll take that.
Yes, ma'am.
Thank you. All right, Vincent Savage.
Deputy, could he come, Mr. Savage, could he come with us? But I'm sorry, he has to have his, yeah, it's okay. Takes him a minute. He has to have his hands to use his walker, Judge, so.
Oh, he can remain seated over there if everyone is okay with him.
That's fine,
remaining
Judge,
seated.
yes.
Yeah. All right, so where are we on this case?
There's a discovery hearing, Judge.
All right, and do you have all discovery or no?
As far as I know, yes.
And was an offer tendered?
Not yet.
State, when will you have an offer in this case?
Just need some time to review it, Your Honor, so I can have an offer at the next time.
All right, so you all have to tender an offer to Mr. Bach off docket.
Okay.
And Ms. Ferguson.
Yes.
Set this in 30 days for a plea deadline date.
October 16th.
Is that good for you?
Yes, Judge.
All right, so we'll be at, Mr. Savage, we're gonna be back on October 16th. That will be your plea deadline date. Do you have any questions, Mr. Savage? All right, thank you.
All right, thank you, Judge.
You're welcome. All right, who is here on Desmond Gomez? Court is calling 2025 CR 007217. State versus Desmond DeBrian Gomez. Could I have parties announced?
Christian Vega for the defense.
And are you Desmond Gomez? All right, we are here for sentencing. All right, according to the plea paperwork, it says that you entered a plea of no contest to counts 1 and counts 3. Is that correct?
Yes, Judge. He was running a concurrent, it was a plea for concurrent deferred. And we were recalled for a TAP evaluation and a MIC evaluation.
No, I'm just wondering because the docket sheet says something different. So I just want to make sure that the paperwork is correct. So count 2 was waived?
I would have to look at it, Judge. I'm sorry.
That's okay,
Thank you.
because I have count 2. Oh, I'm sorry, there are 2 cases.
Yeah, 2 and 1. That's
2 and 1. Thank you.
Thanks, Judge.
All right, so you entered a plea of no contest to counts 1, counts 2, and counts 3. Counts 1 and 3 are third-degree felonies. Count 2 is a state jail felony. And according to your plea bargain agreement, in each case, the state is recommending deferred adjudication. And just one moment. Do you have any objection to the court reviewing the information that probation has sent?
Oh, not at all, Judge.
All right. Have both parties had a chance to review the mental health evaluation and the TAP evaluation?
Yes,
Any
Judge.
objections?
None.
All right, so they're not recommending that he be placed on the mental health caseload. And then with regards to the TAP evaluation, they're recommending residential treatment. Did you want to address that, counsel?
Yes, Judge. Clearly it's within your discretion. There's SATF with aftercare, intensive outpatient with aftercare, and in the event he either anxiety worsened or they due to issues on probation, if there was ever a need for MIC placement, they said they'd reevaluate that. He does not have an extensive criminal history at all, but in addition, regarding drugs, if drugs were involved in the offense, he does admit to substance abuse, several serious drugs. I think he could benefit from some treatment, but he has never been on a probation before. So I think intensive outpatient could, I think that would be very beneficial to him. He's been in custody for quite some time. He's not bonded out, and maybe SATF could be held in abeyance while he does do intensive outpatient treatment.
Probation, what are you recommending as far as, I know the TAP evaluation is requesting residential treatment. What are you recommending? Are you in agreement with the lesser modality?
Judge. I think that he has been in touch. I would be in agreement with the lesser modality, with the understanding if any alternate ways or anything comes up that he would go into status.
All right, and then the other question I have, it mentions that his family's in Beeville.
He does have some family out there. Yes, Judge, but he also has a family in town.
So is he going to be remaining in Bear County?
Yes, Your Honor.
All right, can you raise your right hand for me, please? Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your
All right, you can lower your hand, state your name for the record.
Desmond Brian Gomez.
All right, so I do remember your case. Now that you're before me, do you need a cough drop? Yes, actually. I tend to remember faces, then I can connect that to the facts that I recall. So, when is the last time you had any type of treatment for mental health issues?
Can't recall, like as far as inpatient or outpatient,
Mhm.
I just have a normal family doctor that has given me antidepressants and other medications just throughout the past maybe 6 or 7 years, sure.
All right, so when's the first time do you recall seeing a mental health doctor? How old were you?
They no, probably like 10 years old.
Because, counsel, I'll tell you what, even though I know what the mental health people are saying, what I find concerning is your attempt to commit suicide in the vehicle.
Yes, ma'am.
So are you having any contact with your children now or no?
I've been talking to them over the phone, but I haven't seen them in probably since before I had gotten arrested about 6 months ago.
All right, and who is your support system here in Bear County?
In Bexar County, my grandmother, and I have two aunts that I talk to over here.
All right, how far did you go in school?
11th grade, and then that's when I had my daughter.
Mhm.
And I just stopped going.
So have you worked on trying to obtain your GED? And have you been successful with that or no?
Still in the process. I was in the process right now, while in custody, and I've tried, but I've just it's really been hard for me.
All right. Have you had any type of employment before?
Yes, ma'am.
Doing what?
Surveying.
Okay. So what I'm going to tell you is I'm going to do, I'm going to start you with outpatient treatment. And you're going to have to really communicate with your probation officer because I'm going to grant your application for deferred adjudication. But these cases, if you're unsuccessful on deferred adjudication, and if a motion to revoke is filed, I'm not saying it could happen, I mean that it will happen, but on the state jail felony, you will be looking at 2 years in the state jail facility, and that's day for day. The other cases that are the other counts that are third degree felonies, you'd be looking at 10 years. Do you understand?
Your Honor.
So you're going to have to communicate with your probation officer, and your attorney will tell you in this court, if people are struggling with their drug addictions, all you have to do is let your probation officer know. And you know what's going to end up happening? If they tell me that you're using again, I'm going to receive a supplemental report from them. And they're going to tell me that you're testing positive for drugs. And you know what I'm going to do? I'm going to set it for a compliance hearing. I'm going to have you come in, and we're going to see. And maybe you need inpatient treatment. But if you do this thing where you disappear, that's going to be a major problem. You understand? All right. So this is what the court is going to do. Counts 1, 2, and 3 are to run concurrently. There's to be no contact with Olga Cisneros. The reason why I'm doing that is because all of this started because you all were in a fight.
Yes, Your Honor.
I may change that at some point in time, but for now, you need to focus on you. You understand?
Yep.
There's to be regular reporting by Zoom or in person, regular random UAs, proof of employment within 45 days, no employment as a home healthcare provider or with minors. Take in consideration 2025 PF 13273. There's to be restitution, if any, to Juan Vertiz, Vertiz, James Trottie, Trottie. There's to be the MRT, anger management, 200 hours of community service restitution. The court is going to order parenting classes. Once that's completed, 100 hours will be deemed satisfied. The remaining 100 hours will be deemed satisfied if the defendant obtains his GED or trade school certification. I am going to order the parenting classes, the trade school or certification. That's up to you. Either you can get that done or either you can do 100 hours in the heat of San Antonio. Do you understand?
Yes, Your Honor.
There's to be intensive outpatient treatment with probation and a referral to Center for Healthcare Services and 60 sober meetings in 60 days. Probation, is there anything else? Thank you. Field visits 1 time per month until further notice, and there's to be no residing with minors.
The name for Juan, for the restitution, verify the last name.
Vertiz.
Is Victor B's boy.
Oh, V as in Victor.
That's it.
All right, and there's to be no unsupervised contact with minors. Is there anything else you need from the court to help you be successful on this probation?
I guess it's giving me everything to think that I need as well.
All right, if you need anything else, be sure and let the court know. Counsel, for some reason, I do not have a copy of the trial court certification.
Okay. We can do that.
So if you could just grab one for me, please. Oh, thank you. 5 years deferred adjudication.
Thank you.
It feels like it's a Monday. This is what happens when I leave for a certain amount of time. Do you know in some places people are on probation for life? I've never heard of such.
Sounds difficult.
And I'm sorry, Vashon, you need to write a letter of apology to James Trottie. You understand?
Yes, sure.
No one likes to be spit upon.
Yes, sure.
So, Ms. Abrams, he's going to write a letter of apology to James Trottie. And state if you have that dismissal for me. It's a 2025 PF 13273.
Oh, sorry, Trevor. Got it myself.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, sir.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, sir.
All right, good luck to you.
Thank you.
Thanks,
You're
Judge.
welcome. Simon Garza. All right, has an offer been tendered?
Yes, Judge.
All right, Ms. Ferguson.
And Judge, if I may, before we get a plea deadline date, our investigator was appointed about 2 to 2.5 weeks ago. Could we get one more discovery setting for her to do some work?
All right, Ms. Ferguson, plea deadline date in 30 days.
October 16th.
All right, October 16th.
Okay, thank
So
you.
that should cover you.
Okay.
All right, thank you. Once you sign the reset form, you're excused.
Thank you.
All right, and who is next? All right, so in this case, the state has filed a motion for continuance defense. Are you in objection to the motion?
Yes, Your Honor.
All right, we're going to go on the record. Court is calling 2024 CR 010307 State versus Johnny Joe Aguirre. Could I have parties announced for the record?
Galloway for the state.
Charles Gold from Sagara.
And are you Mr. Geary?
Yes, ma'am.
All right, state, you filed a motion for continuance.
Basis for the motion is twofold. The first one is the complainant that is listed in the indictment pending against the defendant is unavailable for testimony. The state has made attempts to get in contact with this witness, and we believe he is necessary and material to prove our case beyond reasonable doubt. At this time, we've been unable to garner any meaningful contact with him. And then the second reason, I know we are set for jury trial, and in my analysis of the case, I saw that there were multiple gunshot residue swabs that were taken from multiple witnesses that were at the scene, and at this time, we don't have those results. I did reach out to the lab yesterday, and they have still not sent them to me. And so those are the two reasons for the motion.
Judge, I don't believe this is the first not ready. We've been here before on several cases with prior prosecutors. There's an MTR that was held as well. He's already been sentenced on that to 6 years. He's being held in the Bexar County Jail until then. We're asking that this case is over a year old. I think that this case should be dismissed at this time, Judge.
All right, what is the cause number of the case that he's been sentenced on the motion to revoke? Sure. Do you know your cause number, sir, in that case? You-
I didn't represent him on that. Megan Cook
Okay.
represented him on that one. Enrique, I'm sorry, not Megan. Megan, that was
Okay.
wrong Megan.
2023.
Sorry, 50 what?
5468.
Yeah, in fact, it was.
And counsel, I'm just waiting for Odyssey
And
to pull up the case.
And I just told me something else, is that you held on a jurisdiction, you sentenced them, and you're kind of waiting to see what's going on with this case as well,
That's fine.
if I remember correctly.
My Odyssey, okay, here it is.
E-file's been down.
All right, so the court does note that on November 13th, 2024, he was sentenced to 6 years in the prison. And the court did retain jurisdiction to see what the issue was with this case. All right, so with regards to the state's motion for continuance, the motion for continuance will be denied. What I can tell you, counsel and Mr. Geary, there are other cases that are ahead of you.
Mhm.
So if we get to your case, we'll see how the state proceeds. But the motion for continuance will be denied. All right, and so counsel, we'll have you back here at 1:30.
Thank
All right, thank you.
you.
Jacob Anthony Davala. Court is calling 2018 CR 9921, State versus Jacob Anthony Davala. Could I have parties announced for the record for the state?
Rick Pena for the state of Texas.
Donald Wilson for the defense.
And are you Jacob Anthony Davala? Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Jacob Anthony Davala Jr. who was placed on deferred adjudication in 2018 CR 9921 for the offense of assault, impeding breath or circulation, family violence with a previous conviction on April 23rd, 2019 for a period of 4 years and extended for a total of 4 years? Is that you?
Yes, ma'am.
State?
Yes, Your Honor. Violation condition number 20. On or about the 14th day of March 2024 in Bexar County, Texas, the defendant, Jacob Anthony Davila Jr., who then and there failed to comply with the rules and regulations of the Bexar County Community Supervision and Corrections Department Intermediate Sanctions Program as set forth by the court, and that the defendant failed to comply with all conditions of probation and drug tests as directed, and violation of number 20.
How do you plead to that? True or not true?
State will waive remaining violation.
Any objections
No, Your
to
Honor.
the waivers? Did you understand by pleading true to violation of condition number 20, the court could find it true, grant the motion, find you guilty, sentence you to 20 years in prison and up to a $10,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 20?
Yes, ma'am.
Court will find violation of condition number 22 true. Is there a proposed agreement?
There is, Your Honor, that is to revoke the defendant's probation, indicate the defendant guilty, and sentence the defendant to 3 years TDC.
All right, what has he done on probation?
Judge, he's completed the BIP, he's completed ISF.
Yes, he did complete outpatient.
Any objection to the court reviewing the probation court summary?
No, Your Honor.
All right, so why isn't he following through with drug testing?
Judge, what has transpired, as I understand it, is in July of 23, there was an amendment made and Mr. Davala was placed on GPS. And it's my understanding that at that time, when they were fitting him with the monitor, he was asked where he was going to live, and he told them where he was going to live, which included living with his wife and kids. And he was placed on the monitor and was living with the wife and kids. Then in December of 23, the probation officer changed, or somewhere around there. And at that point, they said, hey, wait a minute, you're not supposed to be living with your wife, and started giving him a hard time. And then as it progressed, told him that they were filing the motion to revoke his probation, and things dominoed from there. He was working, he was doing all the other things, but not being able to be with his wife and kids led him to go astray. And there was never a GPS violation. There was, whether it wasn't caught, there was some error along the way. But that was his basis for not doing, not because he was doing drugs or anything like that.
Well, I mean, I don't know if you were doing drugs or not because you didn't test.
Remember when we had a talk and you put me on the gang unit? That's when everything went downhill with the gang unit officer. The first probation officer was going good. The gang unit officer told me I had no contact right. Since I got out of the county jail, I was living there. And then he basically told me he was in the NT Army for no contact. But the GPS monitor, I was living there already for 6 months. I was already living there.
But we're not here for that. What we're here for is you're not doing UAs. So I don't understand why you're not doing that.
I was doing everything until 6 months, they gave me a different probation officer, which was the gang unit. So when everything went haywire from there.
All right, is there anything else? And probation? Did he, other than the drug testing, did he complete everything?
Like I would have to check and review the file as far as the public support meetings and heard. There is a total outstanding balance on the account.
Did you complete your sober support meetings?
Yes, ma'am.
Did you turn those in? That's either yes or no. All right. So here's the problem. When you don't,
Any meetings?
yes.
Yes.
Did you turn them in?
I have to pay.
So here's the problem. When you don't turn anything in, nobody knows that you've done that. That's the problem. All right, this is what the court is going to do. The court is finding violation of condition number 20 true. Court is going to grant the motion, find you guilty. There's an affirmative finding of family violence. Court will sentence you to 4 years in the prison. The court will request the therapeutic community. The court will give you credit for any time served. Did you review probation?
No.
Was there any, I don't see a no contact order with Sandy Davala.
Yes, Judge.
Was there a no contact order?
Yes, Judge. Originally, it was a no harmful or injurious contact. Then that was changed to no contact.
All right, there's to be no contact with Sandy Davala. no unsupervised contact with minors, and no residing with minors. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney?
Yes.
All right, you do have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you're on deferred adjudication. Because this is an affirmative finding of family violence and a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that means, you'll need to speak to an attorney. Do you understand?
So after the 4 years, I can talk to Sandy?
It's best that you do not, and I'm ordering no contact.
Can like do a divorce or something? We just had a baby.
Well, that's something that you'll have to discuss with an attorney.
Alright.
Your problem is that you have this assault choking, and the reason why it's a second-degree felony as opposed to a third-degree felony is because you have a prior family violence case. So you're gonna need to work on you before you're in any type of relationship.
Yes.
And figure out why you get angry with people, what's going on with you. Because children in households, they don't need that because they're trying to learn and they want to be in a household that is serene and pleasant, okay?
Since 2018, I haven't caught another case in good for 7 years.
I mean, I appreciate that, but this is what I want you to ask yourself. Look at your attorney. Has he ever been on probation?
No.
Has he ever caught a case? So you still need to work on yourself. All right? And your attorney did a very good job for you because you were looking at 20 years. You understand?
Yes, ma'am.
All right, good luck to you.
Yes, ma'am.
All right, so in this case, we're here for restitution. Are
Yes.
you all prepared?
Well, we were just served with discovery, and so on that, no, because they're asking for restitution, which we had no notice of until today, about, I don't know, an hour ago.
All right, so State, do you have any witnesses for the restitution hearing?
I did hear, and this regarding the document that she was served, I served them on her. I received it this morning and I served them on her as she appeared.
All right, so do you have any objection to their witnesses appearing by Zoom for the restitution hearing?
Yes, I do, because the lack of, so we filed a 3914 on February of 2024. And to our knowledge, there was no restitution at this point. We don't have the ability, we know that he was paid 30,000 in restitution from a insurance claim out of the insurance that covered the car that my client was driving. And so we don't have those documents. So at this point, we would let the court know that we can't proceed if they're claiming they're still entitled to restitution, even though they've been paid 30,000.
All right, so this is what are your witnesses going to be available at another date or no? All right, if you want to talk to them and see if they're available to testify at another date, if they're not available, I'll take their testimony, and then if they need to be recalled, they can be recalled.
Okay.
And I got your ex parte
There's
request. So what I have to do is I send that it'll be sent under seal to the voucher committee. They'll look at it, and they're very quick about a quick turnaround, and then I can sign off on it.
Okay.
All right.
Judge, he's not available to testify.
All right, I'll take testimony today, and then if they need to be recalled, they can be recalled.
Great. And then, Your Honor, we do have two other issues that we'd like to address today too, just to put on your radar. And that is
To reconsider.
motion to reconsider. And then the second one is that conditions of probation were amended yesterday without notice to the defendant. I think there was a report that was sent to the court that had to do, and it's not necessarily we're objecting to it, but we've not seen it. And he was ordered dual diagnosis outpatient, AANA. We haven't seen any of that documentation. I talked to your court liaison and she said that she can give us copies of it to review. But you'd have to authorize that.
All right, so I had ordered a TAP and MIC evaluation in custody. So are these the results of the TAP and MIC?
The TAP evaluation came back with
dual diagnosis outpatient program. A supplemental report was submitted to the court yesterday or day before yesterday, and it said for those conditions to be amended. Those conditions have not been amended just yet.
Okay.
But it is for dual diagnosis outpatient program, sober support meetings documented, and monthly UAs.
Okay. All right, and do you have, can you let her view the report, the recommendation, the TAP recommendation?
Judge, I need clear direction. The view, are you saying give her a copy of it? Or are you saying let her see it?
She can have a copy of it, but it's not to leave the courtroom.
I'll return it upon after review.
Can you forward that to the voucher committee? All right, court is calling 2023 CR 8868 State versus Samuel Allen Bach. Could I have parties announced for the record?
Megan Gallagher for the state.
Jody Sawyers for the defense, along with Samuel Bach. the
And are you
defendant.
Mr. Bach? All right, so Mr. Bach, the deputy will tell you to stand there. We're here for a restitution hearing and also motion to reconsider conditions of probation. So we'll start with the restitution hearing first. State, do you have witnesses?
Yes, sir. State plus Crows to make us June. Mr.
All right.
Bach?
Could you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand. Make sure you keep your voice up so that the court reporter can hear.
All right,
All right, and excellent. If you'll state your name for the record.
Carlos Dominguez Jr.
All right, you may proceed.
Thank you, Your Honor. Mr. Dominguez, are you the same Mr. Dominguez that testified in the guilt and innocence portion of the trial against Samuel Bach?
Yes, I am.
Okay, and in that testimony, you testified that Mr. Crows Dominguez Senior was your father, is that correct?
Correct.
Okay. Now regarding the death of your father, did you make any arrangements for your father after he passed away?
Yes, Mr. Trevino Funeral Home.
Okay, and did you have any pocket expenses associated with those funeral services?
Yes, we did.
Okay, and did you bring documentation of that to court today?
Yes, I did.
Okay, so I'm gonna show you what has been marked as State's Exhibit number 1.
And just one moment, off the record. All right, you may proceed.
Mr. Dominguez, I'm showing you what has been marked as State's Exhibit RP. Do you recognize this document?
Yes.
Okay, and is this a fair and accurate depiction of the documents that you provided this morning?
Correct.
Okay, and now regarding,
Oh, just one. Just in case.
Thank you.
All right.
I'm showing you what's been marked as State's Exhibit RP on there. Do you recognize that document?
Yes.
Okay, and is that a fair and accurate depiction of the document you provided with us?
Yes.
Okay, now regarding the funeral services for your father, do you recall where they were made at?
At Trevino Funeral Home.
Okay, and is that located on Couples Road here in San Antonio, Texas, Bear County?
Correct.
Okay, and regarding the out-of-pocket expenses that you had associated with that, can you tell the court what was the balance that came out of your bank account?
Objection, hearsay,
Overrule.
and also objection, no personal knowledge. If he's not the executor of the estate, a foundation has not been laid as to him having the authority to have it come out of his bank account.
Well, the question is, did it come out of his bank account?
That's what I was asking, so he would have personal knowledge if it came out of his specific bank account. The counsel's objection, if she doesn't know where it's coming from.
All right, so here's the court's question. Did it come out of your bank account?
My dad's account, which I was the executive for the account.
All right, the objection is overruled.
Okay. Now, what was the total cost that was outstanding for the funeral service?
And Your Honor, I'm gonna object that we have not been provided any documentation that this came out of a bank account. So any testimony in regards to what was distributed from the executor's account we object under 3914 failure to disclose.
All right, objection will be overruled.
It was $4,545.51.
And is that the amount that you paid to the funeral home for the funeral service?
Correct.
Okay. Now regarding your father's home, was at the time of his death, were you living with him or was he living by himself?
He was living by himself.
Okay. And did you have any out-of-pocket expenses associated with his home after his death?
Yes,
Yeah, can you explain to the court what that was?
it was stuff that we were just getting rid of the excess stuff. So we can get rid of the property and everything, because none of the family wanted to keep the property. So it went through a junk lugger.
Okay.
And it took 3 trucks to get it done.
Okay, now regarding that expense, I'm showing you it's been marked as State's Exhibit RP2. Do you recognize this document?
Yes,
And does that appear to be an accurate copy of what you provided me this morning?
yes.
Okay, and can you tell the court what was the cost associated with that removal of the property from the home?
And Your Honor, again, I'm gonna object. This was not provided to us until 9:30 this morning, and we still have not gotten a copy of this. We're just informed that it existed.
All right, objection will be overruled.
You can answer. What was the total cost?
The first cost was $909.30. And the second cost was $1,204.77.
Thank you. You pass the witness, Your Honor.
All right, any questions?
Yes. First off, you would agree with me that the estate of Carlos Dominguez was paid $30,000 from a USAA settlement, correct?
Yeah, I do not recall $30,000. And I don't agree with you on this.
Are you under oath right now?
Yes,
Okay, and you're the executor of that estate?
yes.
And what amount were you paid was the estate paid by USAA for this accident?
That amount I do not recall. The total amount I do not recall.
And was it over $20,000?
I don't recall.
Your Honor, this is why I'm objecting, is because
All right, so here's the thing. I've already made a ruling on the objections. I'm just having him testify now. He can always come back to be recalled to testify. This is what I'm going to tell both sides. With regards to these amounts, if there was an amount paid by USA settlement, then what the court needs to know is whether or not the settlement that was paid by USAA, if it was supposed to be for funeral expenses. It is not, if it's not for funeral expenses, then he is going to have to pay for funeral expenses. Now, with regards to the removal of property from home, everybody needs to bring me case law on that, on whether or not he is really entitled to restitution for that amount. Because what I can tell you, sir, is sometimes people will come to me and they want restitution for, I had to be out of work for a certain amount of days. And I'm not allowed to give, legally, I'm not allowed to give restitution for that. So both attorneys are going to have to bring me some sort of case law that will say that the removal from items from his home that you said went to, you titled it junk removal, and that's what I'll call it. The $909.30 and $1,204.77. So that was removal from items from his home. I'll need some case law on that. If somebody can bring the court case law that he is entitled to restitution based upon that. With regards to the funeral service amount, there's no question for the court that if that amount hasn't been paid by USAA, whatever the funeral expense amount is, that restitution should be paid by Mr. Bach. However, if documentation is brought to the court that in USAA, if that's the insurance company who covered expenses, if it's itemized in there, the funeral expenses, then if it's already been paid by USAA, you don't get to get it paid twice. You understand? So that's what the court needs. So we're going to recess the restitution hearing. And I'm going to give you all another date to come back, and you'll have a chance to look over whatever you need to look over. And then on that date, the court will make a ruling on the restitution. Okay? So do you understand, sir? All right. So Ms. Ferguson, with regards to the restitution hearing, give me a 30-day reset on that, please.
Yes, ma'am, October 16th.
All right. So we're going to continue with the restitution hearing on October 16th. All right, sir. Any other questions
Yes, John.
of him? Okay, she has some more questions for you.
So, do you have access to the bank account, for records for the executor? Like bank account?
That account has been closed. Yeah,
You were the executor, correct?
yes,
And you opened the account?
no,
Who opened the account?
my dad.
Okay, so it wasn't then, the executor's account.
I was on the account with him. When he deceased, well, on the, everything that was there, he had me down as the executor.
Okay, so the funds that, the account that you claim that you paid that, 4,000 and some change for the funeral expenses, do you have, are you on the account? Did you sign the check?
We used the credit card.
Okay, so it didn't come out of the executor's account?
Yes,
Okay, who owns the credit card?
I did.
Okay, so it's your personal credit card that
No,
paid?
no. That's the credit card that my dad and I were to go together, yes. We
Okay,
were together on it,
and so you have access to those statements, correct?
not no more.
So you don't have access to the credit card statements?
I can ask the bank, see if we can go back and on the deal, I don't know what we can or not.
Okay. Now, also, who signed, or accepted the payment from USAA? Was it you?
I did,
Okay, and are you the one that signed the settlement agreement?
yes.
Okay, and so you have a copy of that agreement as the executor?
Just like I said, I'm gonna look at my computer, because I downloaded everything into my computer, and I still have that from my dad.
Okay, thank you, Your Honor.
All right. Any other questions?
No, not from.
All right. Thank you, sir.
Okay, and then,
All right. The next thing we're going to take up is you have a motion to, you can come back, Mr. Bach. You have a motion to consider, reconsider conditions of probation.
yes, Your Honor. At this time, well, at the time of the trial, you ordered 6 months of jail as a condition of probation. And at this time, he served over a month. We are asking for the court to reconsider. He had spent over 2 years on partial house arrest. We believe that he's a good candidate to hold that in abeyance. And you know, if there's ever any issues, you still have that at your disposal. This is not, you know, a give me, it's more of an earned kind of thing. But he did, from the time of the incident, which has been over 3 years ago, he has not picked up any other driving violations. And at this time, we would ask the court to reconsider on that.
All right. Correct me. Wasn't the testimony that he doesn't drive?
No.
I
It
mean-
was initially that he didn't drive after the accident. And then it took a long time for him to get back in the car. Once he got back in the car, he had been driving to work and back. That's it. To work and back. He lives in residential area that, I'm not, sorry, rural area that doesn't have any public transportation. And the second thing to be considered would have been, if he is allowed out, and if that's held in abeyance, then we would ask that he have permission to drive for limited purposes of going to, you know, work, his probation, his also, from what I'm seeing, they're recommending dual diagnosis, outpatient treatment, AA, NA, so he needs to be able to get access to those.
All right. So with regards to the AA and NA, is the court's understanding that those can be accomplished online?
Oh,
Is that correct? I believe it can be. AA and or NA meetings that can be accomplished online.
Providers that have the online capability.
Okay. All right, state response.
We are asking that you deny their motion and leave the sentence as it was imposed by the honorable court on the date of sentencing. Regarding the 6 months, that is something that the state was seeking in punishment, as punishment, given the testimony and or the testimony of the defendant specifically and punishment. And then regarding his being able to drive, I just don't think that, given the facts of the case that were proven in the trial, that there are sufficient means to supervise him in a motor vehicle. And so we're asking that you leave the sentence as it was in the date of sentence.
All right, then the next thing is with regards to the TAP evaluation. Have you had a chance to review that?
I have not, Your Honor. Can you
Okay.
give just a second? Yeah, and so, Your Honor, I have now had a chance to review it, and it looks like he has denied alcohol and marijuana use since January 22nd, 2022. And so at this time, I mean, I'm not quite sure that it's appropriate to order the dual diagnosis outpatient or the AANA, just because it doesn't look like there's a continued usage. It looks like he's gotten a hold of whatever was happening there. That doesn't mean that he doesn't need maybe mental health treatment, but as far as the alcohol and drug usage, that stopped over 3 years ago.
All right. So with regards to the TAP evaluation, they're experts. I'm going to follow the TAP recommendation. With regards to the motion to reconsider conditions of probation, the court is reconsidering those and the motion will be denied. So we will bring you back on October 16th, and at that time, we'll continue with the restitution hearing. All
Thank
right.
you, Your Honor.
And state if you will make sure that if there's any documentation from USAA, that the defense has access to that.
Yes, sir.
All right, thank you.
Thank you, I appreciate it.
Okay.
Have a seat, sir.
Oh, I'm so sorry. Back on the record briefly. So with regard to the TAP evaluation, Ms. Abrams, the court is following that, but I'm not going to order that he be on sober support meetings for the duration of his probation. I'm going to ask for 60 sober meetings in 60 days. All right, thank you. Yes, after release. All right, court is calling 2020 CR 2494B, State versus Willie Contreras. All right, could I have parties announced?
Melissa,
Patrick Valentine for Willie Contreras.
All right, defense, you're not ready to proceed on the motion?
We, on the motion to revoke, Judge, now what we're asking the court to do today is to set a bond on this motion to revoke, and we'll deal with the MTR substantively on the next sitting.
All right. All right, do you have any witnesses?
No, Judge.
All right,
I think both parties have agreed to a recommendation to the court, so that's what we were going to propose today.
all right, state any witnesses?
No witnesses, Your Honor. Just as Mr. Valentine said, we reviewed his criminal history, and if we're only here on the bond issue, then we're prepared to make a recommendation.
Well, in order for the court to set a bond, I need to know about if there's any mental health issues. I need to know if there's any drug issues. So is anyone calling a witness to address those issues?
I can call Mr. Contreras.
All right, you want to raise your right hand?
Yes, ma'am.
Do you solemnly swear affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
You can lower your hand, state your name for the record.
Willie Contreras.
All right, defense, you may proceed.
Thank you, Judge. So you're the same Willie Contreras that was placed on a term of deferred adjudication community supervision back in 2021. Is that correct?
Yes, sir.
And now you're here today and you understand that there's a motion to revoke or motion to adjudicate you and revoke your probation.
Yes, sir.
Okay. The judge is considering today whether to set a bond and what bond amount that should be and what conditions should be attached to that bond. So I'm going to ask you a few questions about that. Are you presently employed?
Yes, sir.
Okay. What kind of work do you do?
Home construction, renovation.
Do you have people that rely on you in terms of financial? Yes. Okay, could you tell the court who those people are?
My kids, my family.
Okay, how many children do you have?
I have 2 kids.
Okay, do you make child support payments towards their support?
Yes, sir.
Do you have any mental health issues?
No, sir.
Have you ever been diagnosed or treated for any sort of mental health issue?
No, sir.
Okay, do you have any substance abuse issues?
Yes, sir.
The offense that you were initially placed on community supervision for was the less than a gram possession of cocaine. Is that accurate?
Yes, sir.
And since that case was resolved, have you used any cocaine?
No.
Do you use any other drugs?
No.
As you stand here today under oath, can tell this court whether you need any sort of conditions related to monitoring substance abuse or substance use?
No, sir.
Thank you. I'll pass the witness.
No.
All right. So what are you all requesting?
Your Honor, we were going to make a recommendation of 7,500 for his bond, if the court would set one on his MTR. He originally had a bond of 2,500 when the case was pending. He did have an FTA before the case got resolved. This court did reinstate his bond at 2,500, and then he was granted probation and subsequently did not perform, as you can see in the motion and court's record. So we're recommending 75.
All right, so he's been missing since, according to your motion, counsel, since June 2022, 2021.
Yes, he never made his first report.
All right. Court is going to set your bond at $7,500. The court is going to order partial GPS for employment only. Waive fees. Ms. Ferguson said this in 10 days for a contested, what date? And I'm so sorry. Could you repeat that?
September 25th.
All right, we'll be back on September 25th.
Yes, Your Honor.
All right, thank you. Ronald Allen. This is for sentencing, correct?
Yes, Judge. We were here previously and there was some ambiguity regarding a protective order that had not been entered with the civil court. And I have a copy of that protective order. That's by Tiffany Allen.
All right, State, have you had a chance to review that?
Copy as well.
All right, so the court is calling 2025 CR 007563, State versus Ronald Lamar Allen. Can I have parties announced for the record?
Charles W. Bexar for the accused.
And you are Mr. Allen? All right, so you entered a plea. Both parties agreed to waive the PSI report. According to the plea, the state was silent on your application for deferred adjudication. The court did request from the state. Does he have any other priors? All right, so court understands that sometimes custody issues, divorce issues can be very chaotic and emotional. What I'm going to tell you, Mr. Allen, is I can grant your application for deferred adjudication. And I've told you this before, but I want you to internalize what I'm saying. If for some reason I grant your application for deferred adjudication and a motion to revoke were filed, if everything were determined to be true, you could potentially go to prison for 10 years. If I were not to grant your application for deferred adjudication and follow the state's request that your punishment be assessed at 3 years with a length of 5 years, if for any reason a motion to revoke were filed, you would be limited to 3 years in the prison. So this is up to you. Do you want deferred adjudication or do you want a felony conviction?
Deferred.
All right, so I'm going to grant his application for deferred adjudication. The deferred adjudication is going to be for 5 years. There's going to be regular reporting by Zoom or in person, regular random UAs, proof of employment within 30 days, no employment as a home health care provider, or with minors. There's gonna be 200 hours of community supervision restitution. I'm gonna order parenting classes. Once that's completed, the court will deem the community service hours satisfied. Now, with regards to the no contact order. So state you've requested a no contact with Charles Ireland, and I believe that's his former attorney.
Yes, Judge.
All right, so there will be a no contact order with Charles Ireland. If your attorney has any type of paperwork or documents and you wish to have those documents, you'll need to have your new attorney reach out to them to obtain those documents. You're not to make contact with that attorney. You're not to go to that attorney's office. Do you understand?
Absolutely.
And then Mark Metley, who is Mark Metley?
He is the attorney of the Tiffany Allen. So we had discussed, Judge, that we had originally asked for no contact order. However, in the PO itself, it asked that Mr. Medley be the broker between communication. So we would just ask that this if the court, if they're willing with honor, I'm sorry, excuse me, order, no harmful or injurious contact.
What I'm going to order is, I'm going to order there's to be no contact with Tiffany Allen or Mark Metley outside of legal communications. So your contact with Tiffany Allen is to be through her attorney and no one else. Do you understand?
Absolutely.
So, and I'm sorry, let me change that. And the reason why I say no contact with Tiffany Allen outside of legal contact is because if you have a court hearing and it's on the civil side, I'm sure she's going to be there.
Right.
So if it's your contact with Tiffany Allen can only be with court hearings or mediations. Do you understand? So there's to be no contact with Tiffany Allen outside of legal hearings. And for the court, legal hearings mean court hearings, mediations. And then there is to be no contact with Mark Metley outside of legal hearings as well. So with Mark Metley, you can email him as long as it's for legal reasons. You understand?
Right, but yeah.
Okay. Now, is there any other no contact orders that's being requested?
Right. So his communication with Tiffany Allen is limited to
Through his attorney?
either
I'm
through his
sorry.
attorney, and they have a co-parenting app that they use.
Yes, either through his attorney or through Mark Metley or in court. And then State, do you have any objections to him having contact with her through the app,
No, you're.
through the parenting app? Okay, and I'll add probation, and also he can contact her through the parenting app. And are you in Bear County?
Yes.
There's going to be field visits one time per month until further notice. And there is going to be anger management. Probation, is there anything else? State, is there anything else? All right, and there will be a $2,000 fine, and that will be probated. Is there anything else you need from the court in order to be successful?
Okay.
Counsel?
Judge, one question for me, will Mr. Allen be free to move about the state in light of these home visits, because they do have a property in Rockport, and he does have an upcoming funeral services that we handled to an order.
Well, with regards to funeral services, as previously stated, and I believe I signed an order, he's allowed to go to funeral services. But outside of that, if he's planning on leaving the county, he'll need to request that from probation, and I'll review it and see if it's appropriate. And just confer with the state on anything that is unrelated to his going to the funeral service, which I've already ruled upon. All right, did you review the trial court certification of defendants' rights to appeal with your attorney? Did you understand it and sign it?
Yes.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, sir.
All right, we can go off the record. So here on out, everything that you do, you need to ask yourself, could this potentially result in me going to prison for 10 years? If the answer is yes, don't do it. If the answer is maybe, don't do it. If you have a question about a condition and you're unsure whether or not you're going to be violating it, pick up the phone and call your probation officer, okay?
I'm wearing a GPS monitor. When does that, did not take effect? I mean,
What will end up happening with regards to your GPS monitor? I'm going to see how you do on that. Probation. With the GPS monitor. State, do you still want him on GPS?
My understanding he's had no violations up to this point, so I would defer to the.
Probation, do you want him to continue on GPS?
But being that there's no violation, no.
All right, so this is what the court is going to order. The court will order removal of the GPS by Friday. You'll need to notify all the persons who have the no contact order that the GPS is going to be removed on Friday. And if there's a violation, then it's not going to be removed. You understand?
yes, sir.
All right, thank you.
Judge, I'm sorry, I have one last thing. We did previously sign an order regarding funeral services on September 30th.
Mhm.
The client has informed me and his family has informed me that there's a typo in that. And I've conferred with the state. I filed a motion to amend the agreed order, and the state agrees that we can change that from the 30th to the 20th.
All right.
Thank you. Thank you, Judge.
And you need to give a copy of that to probation.
I will.
All right, is there anything else?
No, Your Honor. Thank you.
All right, thank you.
Thank you, Judge.
You're welcome. Jonathan Pomerantz. All right, so where are we on discovery?
I had emailed last week that I need access to all discovery. So spoke with the state this morning. They advised me just to bring down an external hard drive. I can bring that to them tomorrow morning for them to upload everything onto it.
All right, Ms. Ferguson, I need a 45-day reset, please.
Yes, October 30th.
All right, and state on that date, you'll need to be prepared to tender an offer. And if there are any CPS records. All right, thank you.
Judge, one
Yes.
question. If I need to file a motion, I need to have the client brought over to have that motion heard, right? He needs to be present.
Yes,
Okay.
or either if you talk to Ms. Ferguson, we may be able to do it by Zoom.
Okay, with the jail. Okay.
All right,
All right,
thank you.
Sounds good. Thank you, Judge.
All right, who's ready?
Yes, ma'am.
Sir.
Emmanuel.
Emmanuel Chavarria.
And just what we're doing, we're asking the court for a couple of weeks, so that we can get a hold of there's a new number one that's the basis for the MTR.
Mhm.
We're asking the court for a couple of weeks, a reset so that we can access the discovery on that case. I'm not on that case, Judge. So that's why we're asking for a period of time.
All right, Ms. Ferguson, I need a 10-day reset for a contestant.
Thank you.
All right, once you sign the reset form, your excuse. All right, anyone else ready?
Yes, ma'am. Edencio Gonzalez, page 1, number 5.
She refused to.
You said what? I'm sorry?
He refused to appear today.
All right, one where?
1, and then the first one, I believe.
All right. Do you have all discovery?
No, Judge, and this is what I wanted to remind the court about. This is one where his discovery is mixed in with the murder case. And Jason had been working very hard to get it the discovery. He even gave it this to Norma to facilitate that. So my understanding is that it should be ready now. And they're double checking to find out where it is so that I can get it.
All right, Norma, give me a reset on this in 10 days. And Deputy Laura, he needs to be brought over on this date.
September 25th.
Thank you, Judge.
Thank you.
I think it's Thomas Wagner.
Thomas Wagner. Yes.
Judge, this is our first setting. I know that on the docket sheet it said 5, but that might have been for some pre-indictment matters.
Okay.
We've received an offer from the state and I'm gonna need to request a psychological evaluation, Judge, so I'm just asking for reset for those.
All right, Norma, set it for a psychological evaluation, and can I have a reset for 45 days, please?
Did you file your motion?
No, I haven't, not for that yet.
Okay, if you can file the motion in the order.
Okay, thank you.
All right, thank you.
Thank you, Judge.
Ashley Rodriguez. And this is this a motion to revoke?
I'm sorry. No, that's a restitution. The restitution. We'll have some resets of them. Sorry.
That's okay. Yes.
Yes, sir. I contacted the victim in this case on Friday and again yesterday, and both times I was told,
All right, so then there's no restitution. Bashan, on Ashley Rodriguez, there's no restitution due. All right, thank you.
Thank you, Judge.
Freddie Lozano.
I don't think Bill's here, Judge. Go to the.
All right, that's gonna come back at 1:30.
James Sanchez.
James Sanchez.
Yeah.
So,
We have a protective order for the court to sign on that.
all right, if you'll pass me the protective order.
Oh, what do we have?
Protective order.
All right, so here's the thing. I've already signed a protective order on this and it was signed on August 14th, 2025. Why do I have another protective order?
Okay, so the issue is this, I can't get discovery on this case for some reason. I've notified the state about that. And so I wasn't sure whether or not you had already signed it or not. So that's why we did another one.
Yeah,
I'm still having discovery issues. I cannot upload any discovery in this case.
all right. Why is he unable to upload discovery state? Do you know?
Discovery matter, if he just brings in a hard drive, they upload all the discovery for him.
I can do that first thing.
All right, Norma, recall this for 35 days. I'm sorry, 45 days.
That would be October 30th.
All right, on October 30th in state, you need to be prepared to tender an offer at that time.
Yes, Your Honor.
Thank you, Judge.
All right, thank you. Once you sign the reset form, you're excused. Sonny Robledo. Robledo.
I didn't bring him, Judge.
Okay, why didn't they bring him?
I
He got here after 11:30.
Oh, so then that's gonna be recalled for tomorrow.
tomorrow. I was gonna, Thursday, Thursday.
Oh, tomorrow is Wednesday, correct?
Yes,
All right, that's gonna be called for Thursday.
thank you.
David Woodard. All right, state. I'm David Woodard's client, Mr. Insuriaga. The defense has filed a motion asking that the removal of full house arrest on GPS.
Would have an objection to that, given the charges. I would have to call the victim right now just to confirm as well, but let me do that and I can get back to you. Is that okay, Ron?
Yes.
Thank you.
All right, Mr. Woodard. The state is gonna call the complainant. And so as soon as they speak with the complainant, I'll take your motion up.
Okay.
All right, thank you. I'll put you both in the waiting room. All right, Gilbert Avalos.
The judge, I conferred with the state, my client, they made an offer. We've been negotiating for a while. And I was hoping you could give us another 3 weeks. I can go through videos and check on our victims.
All right, so today is supposed to be the plea deadline date.
It is.
I can recall it for Thursday. And that will be the final plea deadline date. All right, Ms. Ferguson, recall this for September 18th. All right, thank you.
Thank you.
Once you sign the reset form, you're excused. All right, while we're here on Ms. Dottie.
She went to inpatient treatment. You wanted her to come back afterwards, kind of a status check, see what she's doing, make sure that she's got what she needs to be successful.
All right, and you're still residing at Starlight?
No, I've come home last Monday.
All right.
I've been on full house arrest since then. But I'm doing an IOP program with Starlight.
All right, and has a release been signed with probation? Probation, have you had a chance to confer on how she's actually doing?
Judge, we did last week.
Okay,
From my understanding, she's doing well. No. No issues at this point. She have to educate from Starlight Recovery.
Hmm.
I can obtain a release that I get one signed today.
Okay.
If the court. And
all right, so she's been released from Starlight Recovery. So is she living on her own? Where is she living?
Yeah, I'm living at home in my apartment again,
All right, and who all lives there?
just me.
And what is the requirements that Starlight has you doing?
So I'm doing the 24 course IOP program, 3 days a week, Monday, Wednesdays and Thursdays from 6 to 9. And once I complete that, then, and they have me seeing my psychiatrist, my therapist, and my primary care regularly.
Okay,
So I'm on medication.
and have you given probation a list of those meds?
I just got my new probation officer. I got a letter in the mail, so I have a meeting with him on the 29th. And I sent the lady that's in charge of my IOP, I just gave her the contact information for my new probation officer, so she could be sending him updates and stuff as well.
Okay,
And Judge, I did forward the email I got from Starlight to both the completion certificate, an indication that she had done very well, was very interactive with them. Her participation was very positive. They had assigned her certain leadership roles, so she seems to have done well while she was there.
all right, and so you're saying this is a 24-week course?
It's a 24 courses, so 6 to
24.
8 weeks.
Okay,
And then they do random drug tests as well.
and probation, are you going to accept Starlight's drug tests, or do you still want to do your own?
I would want an independent judge.
All right, so you'll still need to do drug testing with probation.
That's fine.
Is there anything else, probation? How often are you being UA'd at Starlight?
It's random, so they set up to 4 times a month. It could be, but they didn't specify.
All right, so what we'll do is we'll do monthly UAs with probation. And you need to make sure that you do a release so that probation will have access to the UAs that they're doing.
Okay.
All right. Is there anything else you need from the court?
Can I get my ankle monitor on? Cause
What-
I was supposed to get it off July 30th, but then you had me keep it on while I was in treatment.
Yes,
And I.
because I mean, and let me explain something to you. When people are placed on GPS, your attorney will tell you there's a step process for me when I remove it. Because if, we were here in July, there was a motion to revoke. The state withdrew the motion because you were doing Starlight and you were doing other things. So the GPS, what is the status of it? Is it tracking only? What is
It's
it?
for house, but how long have you had it on?
Since May.
All right, so here's the thing. It is at full house right now. State, do you want to do tracking with a curfew, or do you want to start out with partial?
Does she have employment?
No, I'm trying to get employment, but I haven't been able to since I've been on full house arrest.
I'll agree to partial for employment purposes to allow 8 to 5, allow her to go out and look for a job. And then if she finds a job and gets a different schedule, we can return to court to maybe get her a better schedule.
And Judge, I'd remind you the GPS was a sanction.
Mhm.
And then so we went ahead and did that. And so she did sort out that sanction. We did keep it on there to allow her to attend Starlight, know where she was at and make sure she stayed. At this point, I would ask if we're gonna keep it on, that we reduce it down to tracking only. But, the plan had been as a sanction to keep her on till certain dates. And so I'd ask the court to be mindful of that.
The amendment conditions that were done back in April were for her to have the GPS monitor for 90 days. There has not been any, at this point, hasn't been any type of violations.
All right, so this is what I'm going to do with regards to GPS, and you all will have to figure it out. I'm going to do tracking with the GPS. but with a curfew. And then in 30 days, your attorney can come back, and if there are no violations, the court will consider removing it. Okay, so you all discuss the tracking with the time frames, and it can be Monday through Sunday, and you all come up with the time.
Okay. Yes, sir.
All right, is there anything else you need? All right, keep up the good work, okay?
Thank you.
All right, you're welcome. And Luis, we'll just recall this in 30 days. That way we can take care of that. Ms. Ferguson, I need a 30-day reset. Is October 16th? Okay. And if she's employed and there are no issues, she can appear by Zoom.
Okay.
You're welcome. Freddie Lozano. Hello, good afternoon.
Yeah.
All right, what is happening with this case?
There are two outstanding discovery issues we just need to resolve, Your Honor. One is the results of the defendant's buccal swab that was obtained from him. And the second is I need to order a copy of the hospital records from Metropolitan Methodist that the victim had responded to after the incident, and disclose those properly to defense.
All right, and how long will that take?
The subpoenas went out during the lunch break. I would imagine it shouldn't take too long, maybe a 30-day reset. I think we should probably have time to give it to defense.
All right, Norma, 30-day reset on Lozano, please.
Yeah.
And state you'll need to be prepared to tender an offer at that time.
Yes, sir.
And just and for the record, we haven't received any video for this case, and I'm assuming it's not in there.
It should be there. If you don't have it, just bring me a flash drive. I can download it for you.
Okay.
All right, thank you. You have any questions, sir? All right, thank you. All right, yes.
Your Honor, at the lunch break, I was reviewing the state's indictment and discovered that one of our dates in the priors is incorrect. So the state will be tendering a dismissal to refile, as well as we are missing a surveillance video.
All right, any objection to the dismissal?
Yes, Your Honor, the defense would object. It doesn't look like there is also a witness available that would be needed to testify for actual confrontation purposes. So we would object to dismissal on that count. We don't object to dismissal, but we would object to the state refiling.
All right, so I can only address matters that are before me. So because there's no objection to the dismissal, the court is signing the dismissal in 2025 CR 009248.
Yes, ma'am.
Is this the only case your client has?
He has a blue warrant.
Okay. Here you are, sir. All right, thank you.
Have a good day.
You too. Nashia Harrison.
It will be the judge that he did here all this time here. My client already got sent back. I did confer with the state that this is my first hearing. I'm gonna do a motion to press on some issues here, but I've done all I can do today.
Has the state presented an offer?
Yes, I already conferred with the state judge.
Okay. Norma? Set this for a plea deadline date in 3 weeks.
Will that be the suppression hearing date to up to judge?
Oh, you're filing a motion to suppress?
Yeah, I don't need to confer.
State. Defense says they're filing a motion to suppress on Harrison. Is it stop search warrant? What is the issue that you see?
It's essentially a detention issue, how they got into the dwelling. Major
All right,
problem.
so a search issue?
Yeah, the consent. It was an apartment. They got my client coerced her to get in there. She's a victim of the person they were looking for. It's all kind of.
All right, state on, and we're not on the record. I'm just trying to figure out what the issue is. It's Nashia Harrison. So is there a search warrant in this case or no?
Yeah.
2 seconds and I will find out.
A ton of video. I'm learning how to download all that stuff.
I don't believe that
There's something, arrest warrant.
I don't believe that there's a search warrant for them to gain an entry into the residence. I believe they were running surveillance and then observed the defendant associated with the room, and then they go kind of do a knock and talk and then obtain consent to enter into the.
All right.
Actually, they went to the leasing management, coerced my client to go back to her room where she was at and pretty much forced her to go in. So
All right, so,
consent issue.
all right. So here's my question. Is this gonna be a jury trial or not a jury trial? Is the motion to suppress gonna be dispositive or not dispositive? So, yes. Yes, so if the motion to suppress is not gonna be dispositive, then the court can carry it. So, okay. All right, so Ms. Ferguson, on this case, I need a jury trial date. It's a drug case, is that correct?
Yes,
Yes.
Your Honor.
All right, so it should be probably 2 days.
I agree, Judge.
And so we'll set it for jury trial.
And I just have my hearing on that date of the trial. Okay,
Mhm.
so you run it with the date trial?
It's gonna run with trial. So we'll do a jury selection and we'll go with the trial.
Perfect, I like that. Judge.
Okay,
Thank you.
you're welcome.
Thank
October 28th.
you, Judge.
All right, so your jury trial date will be October 28th.
Thank you.
And if you could sign a acknowledgement of discovery before you leave.
Sure.
All right, thank you. So who is ready? Which case? Hello,
Good evening, Your Honor.
good evening. How's it going?
I'm blessed.
All right, so we're scheduled for jury trial.
Judge, I'm going to announce ready for this setting. This is really my second appearance on, because he had Mr. Lyles before.
Mhm.
And as I was preparing, well, actually, last week I was called to Houston for a potential trial, and I was preparing on that all week, and then it went away on Friday. But I was noticing there's 1,800 pages of CPS records that I really need to review before we go forward on a trial setting. That's
So when were those turned over?
I don't believe they have been turned over.
Why not?
Am I correct in that?
I do believe there was, Mr. DeLeon is the second defense attorney on this case. I do believe they were turned over to the previous defense attorney, twice. And so.
I haven't
that's
heard from
where
Mr.
we're at.
Lyles.
All right, so I will tell you what the court is aware of with regards to CPS records. Even though it's 1,800 pages, probably 100 of those are information that's new. Because with CPS records, what ends up happening, every hearing that they have in CPS court, for example, if they were to say on June 1st, it was raining, right? And that's the information from June 1st. They'll have another hearing in August, and then they'll say on August 1st, on June 1st, it was raining. And then they don't have any new information. So of those 1,800 pages, probably 100 of it is new information. The remainder is not. What I'm gonna do is I'm gonna recall you all tomorrow at 9 a.m. for jury selection. And counsel, you're telling the court you have not received those records, review them. And then the court will consider whether or not, if the state is seeking to have those records used, the court will make a decision on whether or not they're allowed to use them.
That'll work, Judge.
All right, so we'll have you back here tomorrow at 9 a.m. for jury selection.
Okay.
Ms. Ferguson, Mr. Mitchell is to be brought dressed for trial tomorrow, 9 a.m. All right, thank you.
Sounds good.
Thanks, Judge.
All right, James Cole. All right, the court is calling 2019 CR 9039, State versus James Arlington Cole. Can I have parties announced? For the defense?
Michael DeLeon for Mr. Cole.
Ashley Jones for the state. Apologize, Judge.
Michael DeLeon still for Mr. Cole.
All right, and are you Mr. Cole?
Yes, ma'am.
All right, did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it?
Yes, ma'am.
Are you the same James Arlington Cole who was placed on deferred adjudication in 2019 CR 9039 for the offense of aggravated assault with a deadly weapon on February 12th, 2024 for a period of 6 years? Is that you?
Yes, ma'am.
All right, state.
Violation condition number 4.
Oh, and I'm sorry, could you announce for the record?
Rick Pena for the state of Texas, my apologies.
All right, you may proceed.
Violation of condition number 14G on or about the 31st day of May 2025 in Bear and or Harris County, Texas. The defendant, James Arlington Cole, did then and there fail to attend, comply with all rules, regulations, instructions, and financial agreements as directed by the court and or supervision officer and or the head of or authorized personnel of the following counseling education program, state accredited battering intervention and prevention program in a violation of condition number 14G.
How do you plead to that? True or not true?
True, Your Honor, I had.
Just one moment.
Judge,
State-
we're gonna be doing true with an explanation.
All right. So with regards to the other violations,
State will waive the other 2 violations, Your Honor.
any objections?
No objections.
Did you understand by pleading true to violation of 14G, the court could find it true, grant the motion, find you guilty, and sentence you up to 20 years in prison and up to $10,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation 14G?
Yes, ma'am.
Court will find 14G true. Is there proposed agreement?
There is not, Your Honor. Both sides are going to go open to the court with our recommendations
All right, state, what are you recommending?
to revoke the defendant's probation, adjudicated guilty, and sentence the defendant to 6 years TDC.
All right, and defense?
Judge,
Do you have witnesses or,
no witnesses, Your Honor, just argument.
all right, what are you
We're
requesting?
going to be requesting for Mr. Cole to be placed back on deferred adjudication, and we like to explain what was going on with the MTR.
All right. Let me hear
And,
explanations.
Let me
Yes.
explain. First of all, on the BIP program, his deferred was transferred to Harris County. That's where he's from. He completed a lot of the BIP program over there. He was exited from the program because he didn't make his payment for the BIP program. Our best estimate is that he completed maybe almost 90%. He was talking about graduation.
So here's my question.
Mhm.
Do we have proof that he was exited from the program for non-payment? No, you can lower your hand. So here's the thing. Let me explain something to you. You're saying I was exited from the program because I was unable to pay. Okay. Your client, your attorney saying he was exited from the program because my client told me he was unable to play. It's like, where's the proof?
Can I speak, Your Honor?
Well, let me just be clear. So is this for failure to pay? That's what
That
is
is, that is our understanding, Judge. I don't know if probation has any more information beyond that, given the fact that this case.
well, let's call probation in Harris County.
Okay.
And let's see if they'll zoom in. And if this is about payment, then we'll see what's going on.
We can find out.
All right?
That'll be fine. Okay, Judge.
Yes.
You have larger support from the VIT program. And on the part report dated June the 4th of 2024, for the month of May 2024, it indicates he attended 11 of 12 sessions. And at the bottom of the report, it indicates there is an outstanding balance. However,
Mr. Dill, can you, I can't see her.
however, I don't have any other updated progress after that. From the BIP program itself.
All right, state, have you reviewed that?
I have not reviewed that, but I'll take her
All right,
word
so
for
if
it.
y'all want to review that, what I can tell parties is this. If the only allegation the state is going on is 14G, and it appears from what Ms. Abrams has said, the progress report she received, there were 12 classes for BIP. He completed 11. And then they say that there's a balance that's due.
Yes.
And I'm assuming the balance that's due is not a balance of another class, but of funds. And what I can tell parties is I don't see how it will be appropriate to revoke him if he's done 11 BIP classes. He only has one more to do and he owes a balance.
And the court wants additional arguments, I'll go into it, but I'll wait for the court.
May state Sept back for a moment, Your Honor?
Yes.
Thank you.
Thank you, Judge.
Sure. You want to confer with the state as well?
Yes.
Okay, thank you.
Okay, have a seat for a little while. Okay. All right, Judge.
All right, Mr. Cole? Is there anything else?
I have an argument if I could make, Your Honor, before you make your ruling, if that's okay.
Yes.
Reason why state's recommendation is what it is because he is on probation for a 2018 offense of aggravated assault with a deadly weapon. 3 years later, he picks up a misdemeanor assault, bodily injury, married co-had, which unfortunately we could not go forward because that victim was uncooperative, but it was a different victim.
All right, so I will listen to what you have to say, but let me explain something to everybody.
Yes.
Y'all are only going on 14G. And that's the only thing that I have before the court. Now, I see the motion to revoke and I see there is a violation of number 1. There's a violation of 14U, but the only thing I've been presented with is a violation of 14G.
Yes, Your Honor.
And he's on deferred adjudication. And 14G, and if there's a disagreement on the facts that I've been given, let me know. The facts that have been given to me about 14G is he didn't complete his battering intervention and prevention program. There were 12 classes. He did 11. They kicked him out of the program because he didn't have money and they're waiting for the balance. And then I guess he can take the final 12. That's what I'm dealing with. If people want to go on other violations, I'm willing to hear that, but you all have just gone on 14G. And what I have on 14G, I don't, well, it would not be appropriate to revoke someone who's done 11 of the classes. They only have 1 remaining. And the reason why they didn't do that 1 is because they didn't have money to pay for it. Now, if somebody wants to present some information to me that he could have paid for it, he just chose not to. He won the lottery. He chose not to use it for that. He chose to do something else. I'll hear that, but I'm just here for 14G.
And Judge, he did not win the lottery. In addition, Judge, he was doing really well the past year and a half. This is his first MTR. He's on deferred. He's employed. He has a CDL. He's a truck driver. He hasn't tested positive for any substances. He's tested all the time and come up negative. If you test him today, Judge, just in case there was any doubt, he would come out negative. He's been in jail in custody for about 30 days already. And we believe that if and he is motivated to get back on deferred. If you place him back on deferred, Judge, he's going to do anything the court wants him to do. If you want him to do the BIP course all over again, he's more than willing to do it.
Well, I don't think it would be appropriate to redo the entire course when he only has 1 class remaining. Is there something else, State?
I make one more additional argument, Your Honor.
Yes.
The violation of the BIP that Your Honor is aware of occurred over a year ago, and as Mr. DeLeon said, his client is gainfully employed as a trucker, which I would assume pays well, and he's had a year in which to try and take care of that particular non-payment to the BIP issue and has failed to do so up to this point in time. Additionally, Your Honor, if Your Honor does not feel like revocation is appropriate, state would, and if Your Honor is considering continuing on probation, state would ask that Your Honor add a jail sanction to his probation that begins today.
All right. This is what I can tell everybody. There's one outstanding class. Am I correct in that?
Correct, Judge.
It appears so, yes, sir.
And this motion to enter adjudication of guilt and revoke community supervision was filed on June 12th, 2025. And we'll have to look in to see when he was actually arrested on this, because sometimes motions to enter adjudication of guilt. They're signed, they're filed. And then if he was in Harris County and if he were arrested in Harris County, he would have needed to be brought back to Bexar County. So these are your choices. You know yourself better than I do. You know yourself better than your counsel does or the state does. I do realize that the state is only proceeding on 14G. I don't understand about this thing from North Carolina on June 8th, 2025. But these are your choices. I can continue you. Or I'll sentence you to 2 years in the prison. Those are your choices.
Which one do you want? You want to be continued? You want to?
Well, I can tell you right now, based upon what's in the motion to revoke, maybe truck driving is not for you. Because the violation, and I'm not considering it, the state didn't present any information. But I see it where it's alleged to have been committed in North Carolina. And I think that's related to he's driving his truck in North Carolina. So maybe he should not be allowed to drive in other states.
Absolutely. And I've had a discussion with my client, Your Honor, and if placed back on deferred, he knows that, you know, if he gets in trouble again, he's gonna be back in front of the 187. So he understands there can be, you know, bad consequences. So, but he has reiterated to me, he does want to be placed on deferred, back on deferred, and he'll do whatever the court asks him to do.
Well, if he wants to be continued and deferred and continue to drive a truck, I'm not gonna allow him in the state of North Carolina.
I think he'll agree to that easily.
Is there anything else?
If your honor would, as you just mentioned, we can see it when you provide evidence of the number one, but just consider the fact that even after doing 11 of the 12 BIP courses, he picked up that number one. That's all I'm gonna say.
Well, I don't know if that rises to the level of preponderance of the evidence, which is the standard of proof and motions to revoke. I don't know if that's something that rises to the level of proof beyond a reasonable doubt. If it's for a jury trial, I just see that there's something in North Carolina.
I present this to your honor if your honor would be willing to look at it over Mr. DeLeon's objection.
Judge, I'm gonna object to that because they waived the number one allegation. So that's something for the court not to consider.
All right, that'll be sustained. So I'm to deny the motion, alternate amendment conditions. There's to be no contact with the state of North Carolina unless he's ordered to be there.
Okay.
Legally ordered to be there, not by your employer says you need to drop off a load in North Carolina. You're not allowed in the state of North Carolina unless in the state of North Carolina, they have a hearing for you in a court of law.
Yes, ma'am. Understood.
Is there any other conditions you request state?
For the defendant as well. Part of the terms of this probation to have no contact with Tamisha Singleton. And that's, if I can spell it for the record, Your Honor.
You said Tamisha?
Yes, TAMESHA, and then Singleton, SINGLETON.
We have no objection to that, Judge.
All right. All right, so there's to be no contact with Tamisha Singleton, no residing with minors, no unsupervised contact with minors. And you're gonna restart the BIP course.
Yes, ma'am.
And Ms. Abrams, that needs to be restarted within 15 days. Is there anything else?
Nothing else, Your Honor.
Thank you, Your State.
All right, we can go off the record. Here's the thing. I didn't really consider that number one because the state didn't proceed on the number one. But I did allow you no contact with Carolina because, of course, you see things and it's alleged to have been committed in North Carolina. It appears that you are a person who should not be in a relationship because you don't know how to keep your hands to yourself. So you need to work on self and figure out why you may or may not, because I don't know anything about that case, are abusive towards people you claim to care about. Because at some point in time, you're going to run across somebody who's somebody's brother, mother, or sister who's going to be very upset with you that you're mistreating their relative, and they're not going to tolerate that. And if something were to happen, you know what people are going to say? Oh, well, you should have kept your hands to yourself. So I don't know why you can't do that. Do you know why you're unable to do that?
Tell the judge what you can do in the future.
Well, no, not what you're going to do. No, not what you're going to do in the future. Why can't you keep your hands to yourself? Why do you keep being abusive towards people you claim to care about or claim to love?
It wasn't my intention.
No, I don't want to talk about your intention because you're here. And the reason why you're here is because you cannot keep your hands off of people that you claim that you love. So I don't want this, it's not my intention, because it is your intention. You know, maybe after something happens, people have regrets. They want to cry, buy somebody flowers and say, I love you, it'll never happen again. And then the next thing you know, it happens again. And then people start gaslighting people, making them think it's their fault. And then they're trying to walk on pins and needles to make sure that you're happy so you won't explode and act crazy and proceed in violence and not in love. So why are you doing this?
I'm not doing it, like,
No, you're here on deferred, that the state agreed for you to have deferred on an aggravated assault with a deadly weapon. That wasn't done in love. And then you have the North Carolina case, which I am not taking as true because nothing is presented. That's not done in love if something happened. So I don't know. Maybe you want to be in prison. And then if you go to prison, you know what will end up happening? And people think I have some control over what happens in the prison. I don't. If I were building a great prison, you know how I would build it? Each inmate at the prison would have their own room. And you know why? Because that would make it easier for the guards. You have your toilet in your room, your bed in your room. You can sleep, not to watch your back for other inmates who probably want to do you harm. So we are back to my question. Why do you continue to do this? Maybe you want to go to prison. And you can get into prison and you could probably end up fighting over there. Maybe you'll win some, maybe you'll lose some. So why are you doing this?
Well, I really don't know, Your Honor. I'm just gonna be honest with you.
I hope so.
I am. I'm gonna be honest with you from my heart. And I really don't be in a relationship with women. They be with me because of who I am and what type of stuff I do, like work and stuff like that. So it really don't be out of love or passion or.
Oh, no, here's the thing. I understand. And I will tell you, I understand based upon cases that I've seen as a prosecutor and defense attorneys, that women sometimes end up in relationships with people and they bring their children along for their relationship. And I'm always thinking, why have women's standards fallen so that they're accepting of someone who's been to prison and they bring in relationship? For example, with you, You have an affirmative finding of family violence. You're on deferred adjudication for aggravated assault with a deadly weapon. You would think a woman would see your history or question you about it before getting involved with you. And they would say, you know what? I have children. I don't want to be in a relationship with you right now. You're on probation. Obviously, you have anger issues, but no. I see it all the time. You know what some women will do? They will meet a guy, even though they have children, they will meet a guy at the club on Friday night, bring them to their home, and they never leave. And the wife will, the girlfriend, the person who picked them up, they'll go to work on Monday and leave that man with their children who they really don't know. And then a child ends up dead or a child ends up raped. And then they're like, oh my gosh, I had no idea. And so with you, you're a walking red flag. And some woman allegedly in North Carolina thought that you would be great. And maybe because you're a truck driver, and I know how much money truck drivers make because there are people in my family who are truck drivers. And who knows, maybe they see you as a paycheck and you think because they see you as a paycheck, you're allowed to do whatever you want to do. You're going to end up, if you continue on this path, you're either going to end up serving a lot of your life in prison, and then you can fight with people at the prison because that usually ends up, that's what happens. I have no control over that. Or either you're going to meet somebody whose father is going to be very upset with you, or their sister or their brother. You understand? I went to a church service, and this guy who was being honored as Christian of the Year, he's been married, I think, for like 30 or 45 years. His wife's like, everything you hear about him is exactly true. I don't have any problems. He's a great guy. So he spoke and he said, people ask me, how are you able to be such a great guy to your wife? And you know what he told them? He said, because I'm a man of faith and I believe in God. And I always think of God as being her father. And I don't want to answer to him. Because he said, if I treat her badly, and her father comes to talk to me, which he says is God, how am I going to respond to that? So maybe if you believe in a higher power, you need to start thinking about the people that you're in a relationship. Their higher power is their father. And they're going to come asking you, why are you treating my child this way? You understand? Yeah. Don't come back here again. Thank you.
Thank you.
Thank you, Judge.
David Woodard.
Oh,
I'm waiting. David hasn't.
That's fine.
Zoomed in.
Just for your clarification, though, he has the wrong case number at the top. The last digit should actually be a 4, not a 5.
Okay, so it should be side never, sorry, 792. What?
Instead of 97925, it should be 7924.
Okay. All right, so state, before we go on the record, Attorney Woodard, is just to see where we are or where the meeting of the minds are between you and the state. So state.
Yes, Your Honor.
Do you object to removal of the GPS?
Yes, we do, Your Honor.
Okay, so then the next question is, do you have any objections to his seeking employment?
We do, because of the victim's concerns that when we spoke, I was on the hall, we spoke with her and she voiced her concerns about the safety of her child, the nature of the charge, the factual allegations that they have been presented. We would object to that as well.
All right,
yes.
so this is what I want you to do. Mr. Woodard, do you have, do you have your cell phone, or can the state call you right now and you're available to speak with them?
They can, Judge. We're not asking that it be removed. We're just asking for partial so that he can work. He's found a job already.
No. I want him to talk to you so he can tell you what the complainant's concerns are. And who knows, maybe you all can address that if you tell him what his work schedule is and the issues. And if you all can't come to an agreement, I'll make a decision. Okay. So he'll call you right now. So maybe that we can address the issue that they're saying that the complainant has. And if it can't be addressed, I'll hear it and make a decision. They're going to call you right now, Mr. Woodard.
Okay.
All right, court is calling 2025 CR 0011193, State versus Oscar Patlan.
He's
All right, he can remain there. Yes. Could I have parties announced?
Megan Galloway for the state.
Dwight Chumley for the defense.
All right, are there any applications in this case?
No.
And are you Mr. Potline?
Yes, ma'am.
Counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Potline, did you review the true bill of indictment with your attorney? Did you understand it? Did you understand it? I'm sorry, what?
Do you understand the indictment? He's very hard of hearing.
All right. Mr. Potline, this document tells you what you're charged with. Did you review that?
Yes,
Did you understand it?
yes, I did, ma'am.
Counsel, do you waive the reading of the indictment?
I do, Your Honor.
State, are you proceeding on the indictment as presented?
No, we're waiving the enhancements, Your Honor.
Any objection?
No objection.
Mr. Potline, did you review this document? It's the admonishments. It tells you what you're charged with.
Yes, ma'am.
All right, you're charged with possession, penalty group 1, less than a gram. That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Do you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. By entering this plea, you were giving up those rights. Did you intend to give up those rights and enter into a plea?
Yes.
Did you understand that if you have a plea bargain agreement with the state, the court does not have to follow that plea? If I do not follow that plea and give you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Do you understand?
Yes, I do.
Counsel, has your client been able to provide you with any defenses?
He has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
I believe he is. Yes, Your Honor.
Mr. Potline, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, Your
Anyone promise you anything other than the plea?
Excuse me.
Did they promise you anything other than the plea bargain agreement? Are you satisfied with the way you've been represented?
I think it's okay, ma'am.
No, my question is, are you satisfied with your attorney?
Yes, ma'am.
All right, do you understand that if you're not a United States citizen, by entering this plea, you can be deported, not allowed re-entry or naturalization? Did you understand?
Born and raised here, ma'am.
All right, did you understand?
Yes, I understand, yeah.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page?
Ma'am,
The plea bargain, did you review that with your attorney?
she told me by people.
All right, so according to the plea bargain,
Yes, ma'am.
your punishment is to be assessed at 6 months in the state jail facility, $1,000 fine, and you're not applying for probation. Did you understand that?
No, ma'am, you didn't say nothing about no probation.
You are not applying for probation. Do you understand?
Oh, yes, ma'am.
Is that the plea?
Yes.
Defense?
It is state.
I'm sorry, state.
It is, Your Honor.
Did you review the waiver of appeal paragraph?
Yes, ma'am.
Did you understand by signing that the only way that you can appeal the court's decision is if I don't follow your agreement or there are some pretrial motions that I've heard and ruled upon? Did you understand that?
Yes, ma'am.
Have there been any such motions?
No.
Then how do you plead? Guilty, not guilty, or no contest?
Plead guilty, ma'am.
State any evidence.
State offer states 1 in attachments.
Objection.
All right, state, you may be excused. Did you review these stipulations with your attorney? It contains the police reports and the laboratory reports. Did you review that with your attorney?
Yes.
Did you understand it?
Yes, ma'am.
All right, you understand by entering this plea bargain agreement, the state is not going to bring any witnesses into court. They're just going to ask that I read this document and see if there's enough evidence to find you guilty. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. After reviewing state's exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes,
Anything you wish to say on behalf of your client?
only that he is in ill health. He has been in a hospital room now for over a week. I believe since his arrest. So if there's any way he can do some sort of unit there where they tend to the health of their sick inmates.
All right, the court will sentence you to 6 months in the state jail facility. There's $1,000 fine, time and money to run concurrently, and I'll request the therapeutic community. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you need to speak to an attorney. Do you understand?
Yes, Your Honor.
All right, good luck to you, sir.
Thank you, Your Honor.
You're welcome.
Thank you, Judge.
Thank you. God bless you too. All right, are you all ready on Ensiriaga?
Yes, Your Honor. Both Mr. Word, thank you to make a roll.
Okay. Let me just put this in here very quickly.
Sure.
All right, the court is calling 2025 CR 007924, State versus Matthew Ensiriaga. Can I have parties announce?
Rick Pena for the state of Texas.
David Andre Woodard for Matthew.
All right, and Mr. Ensiriaga, if you'll show your video, please.
Yes, ma'am.
All right, the defense and the defendant are appearing by Zoom. Any objection?
Nothing more state.
All right, the court is in receipt of a motion. The defense is requesting that the defendant be removed from full house arrest and be placed on partial house arrest and be allowed to work. And you have objections?
I do, Your Honor. We spoke to the mother of the victim in this case, and she voiced her concerns for her child's safety. Given what happened factually as alleged and given the charge that this defendant is facing against her, she was not comfortable with the GPS conditions being changed.
All right, defense, do you have any witnesses?
We do, Judge. I'd like to ask Matthew questions.
All right, can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Matthew Ensiriaga.
All right, defense, you may proceed.
Matthew, have you found employment?
Yes, sir.
And where have you found employment?
I've gone through a temp agency, Rent Hill Staffing, and they helped me get jobs. And the job they helped me with get today is at it's a third shift at 5501 Business Park. It don't say the company's name. Oh, yeah, I don't say the company's name. Just the supervisor.
What days would you work?
Sunday through Thursday.
What time?
From 10 p.m. to 6 a.m.
Okay, since you've been on GPS, have you had any violations?
No, sir, not that I know of.
Have you had any contact with the alleged victim since you've been on GPS?
No, sir.
Do you intend on having any contact with the alleged victim?
No, sir, I do not.
Are you asking the court to change your GPS conditions from full house arrest to partial house arrest so that you can work?
Yes, sir.
Judge, we'll pass the witness.
All right, any questions?
Yes,
State.
Your Honor. Mr. Ensiriaga, can you hear me?
Yes, sir.
You mentioned that you'd found employment. Was that today?
Yes.
So I'm assuming you had been looking through the temp agency like you had mentioned earlier, correct?
Yes, sir.
Okay, what kind of job is it again?
It's a warehouse job.
A warehouse job. Do you know who you'd be coming into contact with at this job?
Yes, I have the supervisor's information and number.
Okay. Does that employment involve you coming into contact with any minor children at all?
No, sir.
And did you make this employer aware of these pending charges against you?
Yes, sir. I told the staffing agency about it.
Okay. I have no further questions, Your Honor.
All right, anything else?
No, Your Honor.
All right, the court is going to grant partial GPS for employment only. And it will be defendant is allowed to work Sunday, from Sunday through Thursday, 10 p.m. to 6 a.m. with 30-minute. How far is the employment from your home?
Let me look it up real quick. It is 18 minutes.
18 minutes? All right, with 30-minute travel time to and from work upon proof of employment and hours. So what that means is you cannot deviate and stop at McDonald's or stop anywhere else. You're only allowed to leave your house, to go to work, and to come back home. Do you understand?
Yes, ma'am.
If you violate these orders, if you stop at McDonald's or if you stop somewhere else along the way to work, there will be a violation. The court will receive notification and we'll have a hearing on whether or not you should be continued on bond. Do you understand?
Yes, ma'am.
All right, is there anything else?
Nothing from the state.
All right, thank you.
Thank you, Your Honor.
Yes, who are you here for?
Brian Martinez Mejia.
Odyssey is taking a little bit of time to upload.
And that's all we need, Judge. Just a little bit of time.
All right. Yes.
So actually, they've tendered an offer that is within the realm. We have some differences of opinion. And so we're still going through it. And if we could be granted just a little bit of time so that we can discuss it in detail. So the formal offer was made today. We just need some additional time, a couple of weeks, 2-3 weeks to.
I'll recall you back on Thursday.
That would maybe, with what's going on, I'm not asking for what I believe to be a lot of time. I'm out next week. If we could be just 2 weeks maximum.
Are you out this week?
No, I'm not.
Because this was set, and the reason why I say that, this was set for plea deadline day today. So I will see you all back on Thursday. Okay?
Okay.
All right, thank you.
Judge?